Item 16, ये 1907 of 2026.
The leadership problems are the right to withdraw CW 49 on the instructions of 49, not on the test.
Serial number 49.
49
The learned counsel for the petitioner seeks permission to withdraw this petition. Permission is accorded. This petition is dismissed as withdrawn.
Fine.
It is under cyber law. It's under cyber offense.
Yes, sir.
Supplementary list.
On the daily list.
Daily list. Okay. Yes.
Item 16.
Yes. I don't remember. You just
The matter is to cybercrime in your edition and only persons get apprehended in which the main co-accused on whose mobile phone the WhatsApp chat has been recovered of one Pratap and co-accused Himanshu Deepak Kumar in large on bail, and only on his mobile phone WhatsApp chat conversation has been received in which they were talking about the transaction.
Any antecedent?
No, your edition. There's no antecedent. It has come in the case diary.
What do you have to say? Why the SP office Ranchi is not responding to your letters? Why the SP office Ranchi is not responding? Because SP office Ranchi was directed to provide the details of the complaint registered on NCRP portal. Why is he not responding?
Investigation is going.
They, within
They
IO and SP, what investigation? IO had written a letter to the SP Ranchi to provide the details.
Yes.
Why is he not providing?
supplementary case diary not.
Heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 9/7/25. In connection with the alleged offence, the petitioner has no criminal antecedent and two co-accused, namely
One co-accused leadership, Deepak Kumar Himanshu, and supplementary charge sheet is pending for
namely Deepak Kumar Himanshu has been granted bail
in BA number 9830 of 2025.
in BA number 9830 of 2025. The learned counsel submits that no victim has come forward and has no criminal antecedent. Counsel for the state has opposed the prayer and has submitted that investigation is still going on.
Against other court is
Further investigation and investigation under co-accused.
supplementary investigation, not supplementary.
The supplementary investigation and investigation against co-accused is going on.
Against
Co-accused.
this charge sheet has been submitted.
भाई चार्जशीट तो 3 महीना में आपको जमा करना पड़ता है, उसके बाद कोई मटेरियल आ जाएगा तो इसका पिटिशनर में नहीं यूज होगा.
तो वो supplementary
3 months में you have to submit the charge sheet, otherwise it will be released on.
90 days, yes.
Yes. There may be further investigation, many things may come up against the petitioner even in supplementary investigation, isn't it? That will not be considered.
Yes, yes.
Then?
It will be considered.
Supplementary investigation and investigation against the co-accused is going on. But the submissions made by the petitioner are not in dispute. After hearing the learned counsel for the parties and considering the fact considering the custody of the petitioner and the bail granted to the co-accused, the petitioner is directed to be enlightened on bail.
The supplementary list are ready for admission. Item 1, BA 741 of 2026.
Sorry, yes, you have argued it yesterday, right? Co-accused has been enlarged on bail.
Co-accused has been enlarged on bail, and the case specifically made allegation with regard that there is nexus with of the petitioner with Bangladesh and USA. But that statement is recorded in case of Chhattisgarh, and in that case also he has been granted bail.
That's
But Manoj has anything to do with that?
I see. That order of Chhattisgarh court is also.
No, that is not there. But one of the co-accused who is also partner of this petitioner,
That's
he has been granted bail.
that's.
Yes,
Give me that order. Order it. What is his name?
Arun Trivedi.
This is the order in Chhattisgarh, no?
And annexure to that annexure to page 62, by which the co-accused has been granted bail by this honorable.
Page number 60.
62. He is the partner as per the FIR itself.
As per the FIR, all the cash transactions have taken place with this co-accused Abhishek Singh Gharwar, and there are transactions through your bank account. उनका कोई बैंक अकाउंट इन्वॉल्व नहीं है.
मेरा भी हम जब शुरू से ही दो बैंक अकाउंट ऑलरेडी हम दिए हुए थे. जब उनको ऑलरेडी बैंक अकाउंट दिए हुए हैं, लोग उसमें ट्रांजैक्शन कर रहे हैं. There is no reason to receive any amount through cash.
That's okay. Heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since
12 to 2025 in this case.
12 to 2025 in the present case, and he has submitted that the petitioner has been falsely implicated in this case, and the petitioner has also returned an amount of rupees 10,75,000 and all.
That's come in the FIR.
That is mentioned in the FIR itself. He has further submitted that the co-accused, namely Abhishek Singh Gangwar, has been enlarged on bail by coordinate bench of this court on 13/10/2025 in DA number 5123 of 2025. He has also submitted that the petitioner is also an accused in the case registered in Chhattisgarh, wherein there is an allegation.
Similar.
Just a moment. There is an allegation wherein there are similar allegations, but he has been enlarged on bail. One bail order has been produced before this court, passed in NCRC number 8213 of 2020.
This is from the Jabalpur High Court.
In connection with another case, the Honorable Jabalpur High Court has also granted bail to the petitioner. Yes.
There are 4 similar cumulative incidents. So one of the cumulative incidents in Madhya Pradesh, where the one company of international cyber crime is co-accused with this petitioner. For that international cyber crime जो उनका कंपनी है, उसके साथ इनका connivance है, जिसमें इन्होंने उस कंपनी में भी ट्रांसफर कराया in similar manner.
Which paragraph of the case idea? Okay.
That is described in part 121 of the case.
121.
Yes.
His connivance with international cybercrime.
Yes, and that is read with para 49 notes. 49 notes जो केस का स्पेशल डिस्क्राइब किया हुआ उस केस के बारे में MP वाले.
And that MP case is pending. Where he says he has been granted bail.
And उसके अलावा भी 3 other cases are also pending in similar manner. सारे crime similar manner में हुए.
सारे केसेस में बेल हो गया आपको?
एक
एक करके क्यों दे रहे हैं?
दे रहे हैं 4 This is the chart.
क्रिमिनल केसेस का चार्ट है ये वेरी
इन्फॉर्मेंट ही नहीं,
Individual and
इन्फॉर्मेंट ही नहीं, इन्फॉर्मेंट 1 करोड़ कुछ लाख 11 लाख का हुआ। इन्फॉर्मेंट के अलावा सेवरल विक्टिम्स का स्टेटमेंट्स है कि दे हैव स्टेटेड दैट दिस अरुण द्विवेदी कम एंड टेकन अमाउंट in different company.
The learned counsel for the state has opposed the prayer and has submitted that and had submitted by referring to paragraph 49 and 121 of the case diary to submit that in the criminal case lodged at Jabalpur in Madhya Pradesh, the involvement of the petitioner in connection with transaction of money has been found with respect to international cybercrime. He has further submitted that the petitioner has as many as 5 criminal antecedents. 4 apart from the present case.
Yes, apart from this.
And all of them are similar in nature. He has further submitted that the co-accused, the allegation against the co-accused is different from that of the petitioner in as much as the petitioner has taken the alleged money in his bank account, but no such allegation is there with respect to the co-accused. After hearing the learned counsel for the parties and considering the serious allegation made against the petitioner, who is alleged to have cheated the victims with rupees 4.65 crores and odd, and altogether, out of them altogether 1.18 crores and odd is shown to have been transferred in the bank account of the petitioner.
Not the entire number.
1.18 crores and odd.
Only 57 lakh as per my calculation.
Promise in total 1.18 was
That's-
transferred in different bank accounts of
But
Arun
one
Kumar.
account which is not in my name, but in that account 66 lakhs has been paid. But that is not in my name. That is in the name of one Velocity Enterprises and that.
And out of them huge amount has been shown to have been transferred in the account of the petitioner. Copy? हम amount ना भी लिखें तो क्या करें? Considering the fact that very good trial नहीं चल रहा यहाँ पर. Considering the fact, considering therefore say and this court also finds that there are numerous criminal cases of similar nature pending against the petitioner. Though in some of them the petitioner has been enlarged on bail by the concerned court in Madhya Pradesh. So sorry, in Chhattisgarh. Considering this, this court is of the view that the case of the petitioner is different from the case of his co-accused Abhishek Singh Gangwar, in whose connection no bank account transfer has been alleged.
And several victims have also stated that they have also been cheated. Also, they are witnessing this.
Numerous victims have come up, has been mentioned in the case diary, who have been defrauded by the petitioner and also the co-accused. This court is not inclined to enlarge the petitioner on bail, hence rejected.
Item 2, DA.10.04.2026.
Counsel for the petitioner seeks permission to withdraw this petition. Accordingly, this petition is dismissed as become.
Item 3,
इसी
DA.10.
तरह रख लेंगे तो उस वो ऑर्डर में ये
Each cover either has been given by the in-laws in Montana.
What is it?
Item B.
In this matter also the co-accused has been
क्या है? कौन दिया है?
Nodal.
अच्छा.
also in this matter also co-accused has been admitted by the committee. The
Right.
only difference is that the name of this petitioner has come in this.
मुझे ना काम करना. इसको खोलिए जरा. BA number 1070 of 2026. For the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the court use has been enlarged on bail. Namely,
I have alleged from
Edward Marandi
and lordship has granted bail to the another co-accused. They are
in BA number
BA number 644/26%, Rajesh Tudu.
excuse, in BA number first Edward Marandi in BA number 9419 of 25. ये page 28 में order है इसमें. And another co-accused namely Rajesh Tuddo in BA number 644 of 2026 by order dated 8/4/2026. However, the learned counsel for the petitioner has fairly submitted that the name of the petitioner has come up, the FSL report is not in favor of the petitioner. That should be sufficient. Envelope में क्या होगा? FSL report ही होगा.
ये envelope से नहीं निकालना.
अच्छा जी. The statement of the victim recorded under section 183 BNS has been placed on record, has been placed by the learned counsel for the state, upon perusal of which this court finds that the allegations, she has supported the allegation.
May I say what?
Trial is at Fagin.
Out of 8 prosecution witnesses, 4 have been examined and the victim has turned hostile during examination before the court of Section 3.
That's
Comment has also
Yes.
turned.
The learned counsel, at this learned counsel for the petitioner has submitted that out of 8 prosecution witnesses, 4 have already been examined
All 4 have turned.
and all 4 have turned hostile, including the victim.
Victim and informant.
Victim and the informant. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, particularly the FSL report, which even according to the counsel for the petitioner shows some connection with the petitioner, the case of the petitioner stands on different footing as that of other co-accused. Accordingly, this court is not inclined to enlarge the petitioner on bail. However, the trial is in progress. The remaining witnesses be examined by the court at the earliest. The state is directed to promptly produce the remaining witnesses before the court. FSL चला जाएगा ना, including the FSL report that may be produced before, that is directed to be produced before the court. The counsel for the state is directed to communicate this order to the SP of the concerned district and also to the director of prosecution. ये सब envelope में डाल के इसको pack करना.
जी. Item 4, DA.10.08 of 2026.
Thank you for passing.
Counsel for the petitioner. ठीक है, पास हो गया. 12 बजे.
Item 5, DA.13.49 of 2026.
Are you there, madam, in this case?
Senior will argue in this case.
Sorry?
My senior will argue in this case. Wait for a short pause so
12 o'clock. चलो next.
Item 6, BA1422 of 2026.
Okay, 6 and 7 both are.
12 बजे.
Item 7, BA1424 of 2026.
12 बजे.
Item 8, BA1550 of 2026.
University, I am appearing on behalf of respondent number 2.
Where is the petitioner? Petitioner absent, post on 20th. Be secretary.
Alright.
Item 9, BA1561 of 2026.
Pass over to us.
12 o'clock.
Item 10, BA1595 of 2026, along with item 11.
So we will
It's a case of cybercrime, three mobile phone seized from this petitioner. When he has been granted deadline, there is no victim,
antecedent.
no antecedent, anything like this.
आप हैं सचिन कुमार. Yes. सचिन कुमार को कैसे क्या होगा?
Charge sheet है.
Charge sheet submitted when?
28 to 26.
एक बात बताएं. Listen, in this particular case, as I could find out, this transport department challans are sought to be recovered by committing fraud. It is something like somebody will call you that there is a fine imposed on you, so you pay it through wallet or whatever, and then they take the money and actually does not go to the department. Right? There is no investigation from the transport department. Victim will not come, no, because victim might not know that payment has not been made. Victim will say that yes, my payment has already been made. There is a e-challan.
Please silent.
Yes, that is why you are not getting the victims. You will not get the victims over here.
हम लोग का गाड़ी में भी तो होता है चलान लोग. वो सिंपली एक मैसेज
बस
लिंक क्लिक करते हैं और हम लोग पेमेंट करते हैं.
पेमेंट यही है ना.
यही
लेकिन
वो मैसेज करते
अरे
हैं.
भाई तो आप विक्टिम को खोज कहाँ रहे हैं? क्योंकि जिन लोगों का चालान जनरेट करके ये लोग बोल रहे हैं कि पेमेंट किए हैं, उन पर कहाँ इन्वेस्टिगेशन कर रहे हैं आप? इसीलिए आपको विक्टिम मिलेगा ही नहीं. इसमें कोई कंप्लेनेंट नहीं होगा because the state is the victim in this case. Technically the state is the victim. किस तरह का इन्वेस्टिगेशन करते हैं आप?
विक्टिम एक ट्रेस आउट होगा. फिर वो मैसेज जो लिंक क्लिक करके किया उसको
ऐसा केस डायरी से नहीं लग रहा है कि आप लोग ऐसा कुछ कर रहे हैं.
वो किया नहीं. किस तरह
Nothing has been done. Third, the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that there is no criminal antecedent of the petitioner and no victim as such has come up has been found during investigation. And even the mobile of the petitioner is not linked with commission of any cyber offense. हमको तो नहीं दिखा आपका मोबाइल नंबर।
इसी बोलते हुए कि आरटीयू का ये चालान देखिए फाइल देखिए
कोई बात नहीं। The learned counsel for the state, by opposing the prayer for bail, had submitted that the RTO e-challan, that large number of persons, that a large amount of money has been recovered by fraudulently generating RTO e-challan, which has ultimately not been credited in the account of the state. However, during the course of argument, it is not in dispute that no victim as such has been mentioned in the case diary in connection with whom e-challan has been generated, and admittedly the petitioner has no criminal antecedent. The petitioner is in custody since
8/12/25.
8/12/20. The co-accused, namely Mahesh Kumar Mandal, has been enlarged on bail in BA number 2375/26 by a coordinate bench of this court. After hearing the learned counsel for the parties, considering the custody of the petitioner and bail to the co-accused, the petitioner is directed to be enlarged on bail. Dusra case, next. Your case is not similarly situated. No. Your mobile number has been used. Their mobile number has not been used.
But
67 is your mobile number. 167.
167.
Right? That has been used.
For the question of
Yes.
this petition. But also in this, no transaction has been made in my bank account.
No transaction has been recorded through your phone.
No transaction in the bank account also. I got no criminal antecedent also.
In his phone, RTO e-challan and APK files were
Yes.
Those there was screenshots of all those. But nothing, no transaction in the bank
पुलिस
account.
रहता है, स्क्रीनशॉट तो पुलिस रहता है, इनके मोबाइल में APK फाइल्स
आप लोग सही से इन्वेस्टिगेशन ही नहीं कर रहे
RTO
हैं।
e-challan was found.
You are not actually investigating the case properly. The persons whose e-challan is found, they are the persons whom you have to contact. Because they will tell you that they have paid the amount. The state is the victim in this case. And they are the victims. They would not know that this challan is forged unless they get a fresh notice for the same challan. But if I have already paid the challan, I would only know that I have paid the challan. Then I will not come forward and make any complaint. Same order per day. No antecedent?
No antecedent. Yes, sir.
I don't know whether you will communicate this to your officer or not. But this is what is happening in this case. You should. Yes, Mr. Tiwari, you also do the needful. सही से जिसके जो victim है लोग उनके सच्चाई नहीं रहे.
एक्चुअली डायरी जो हम लोग के पास आता है जिसका एनेक्स्टर्स नहीं आता है। सेकेंड चीज हम लोग के पास डायरी तब आता है जब चार्जशीट सबमिट होता है। हम लोग कम्युनिकेशन करके भी पहले बहुत बार देखे लेकिन उसका रिस्पॉन्स
नहीं ऐसा
माने
है
हम एकदम फैक्चुअल
नहीं
और इरेटर
you
से
see I tell you one thing now for all the cases arising out of same FIR only one case diary is required duplicacy हमको नहीं चाहिए point number 1 then I will pass an order to produce the case diary along with its enclosures भले वो कितना ही मोटा क्यों नहीं otherwise you know how the complexity etc is there is not coming एक सेट केस डायरी आई विल पास एन ऑर्डर अकॉर्डिंगली कोर्ट में रहता है कि कनेक्शंस रहता होगा कोर्ट में तो
बहुत सारा हम लोग खुद अपने देखते हैं कि डायरी में रहता है उसका क्रिमिनल इंसिडेंट रहता है उनका जो रिपोर्ट्स आता है उसमें बोलता है देयर इज नो क्रिमिनल
ठीक है इंक्लोजर के साथ ही अब केस डायरी
जैसे पिछले बार हम एक केस में आर्गुमेंट किए थे कि जिसमें 100 कुछ एफआईआर
हाँ
ऑलरेडी उसकी रिपोर्ट जबकि उसका क्रिमिनल इंसिडेंट ऊपर एक पेज कर देते हैं एज पर माय रिकॉर्ड देयर इज नो क्रिमिनल
क्योंकि वो आप कंसर्न डिस्ट्रिक्ट से ले रहे हैं ना कंसर्न डिस्ट्रिक्ट में वो एफआईआर लॉन्च नहीं है
अच्छा सेकंड चीज एक और हम लोग देखते हैं कि इसको चार्जशीट सबमिट करके इन्वेस्टिगेशन को क्लोज करने में ज्यादा लोग तत्परता दिखाते हैं कि मेरे यहाँ एक केस क्लोज हो गया उसको क्लोज करने का जरूरत नहीं है एक केस से अगर कंटिन्यू इन्वेस्टिगेशन करेंगे तो उससे सेव है उनका एक केस में अगर 5 एक्यूज अरेस्ट हुआ तो उसका लीड अगर उसको पकड़ते चले जाएंगे ना तो पूरा एक बड़ा सा 100-200 का पूरा गैंग ही आ जाएगा लेकिन देखते हैं उसको उसने 4 एक्यूज तक इन्वेस्टिगेशन
ट्यूसडे को बात करेंगे आप अपने डायरेक्टर प्रोसिक्यूशन से इन सब बातों में बात करके रखिए
सारे बात कर रहे हैं
सारा एकदम पॉइंट वाइज बनाइए और हमको मंडे को ही दे दीजिएगा क्या क्या पॉइंट आप बनाएंगे ठीक है
Item 12 DA1673 of 2026.
It is a case of dowry death match. The cause of death was not ascertained. But on the last occasion, direction was issued to bring on record the report of the FSL report.
आगे
हाँ,
क्या है?
आया नहीं है।
आपको मालूम है
हाँ,
अभी तक हमको नहीं पता चला
मुझे काउंटर में ही कह रहे हैं क्यों
नहीं नो मेटालिक एंड पॉइजनिंग नहीं पाया
नहीं but even the postmortem report if we are allowed to when there are no external injuries also
she died due to hanging
Yes, sir. On the English report, my lord, kindly see the English report. हमारा both 3 of the case diary, my lord. उसमें लिखा हुआ है कि शरीर में दिखाई पड़ने वाला जो घाव, उसमें गर्दन में दाग का निशान है और उसके बाद जो विटनेस है, मृत्यु कारण के संबंध में कॉलम 9 हमारे दोनों का मैंने बताया गया कि गला में दबाने से मृत्यु होना प्रतीत होता है। और ये 9 मंथ एक मिनट जब पोस्टमार्टम एक मिनट सर हमको रिक्वेस्ट
आप तो नहीं आप स्टेट ही
This is the husband of the
postmortem report का एक बार देखिए
so she died without any reason
but it is a natural death but it has not been ascertained my lords as to how the death has been caused
in the inquest report she was found where
but the purpose of the inquest
she was found dead where
मतलब in the house
matrimony
मतलब एक पैरा 39 एक बार देखिए पैरा 39 अब एक बार खाली पोस्टमार्टम रिपोर्ट खाली दिखा दे एक बार पहले पोस्टमार्टम रिपोर्ट एक बार देख लीजिए उसको
ये क्या चीज है
ये पैरा 39 की इंक्वेस्ट रिपोर्ट का क्या पर्पस है इट इज
ये ट्रायल नहीं चल रहा
मतलब ओनली लिमिटेड
That's right.
और पोस्टमार्टम
इट्स अ मैटर ऑफ ट्रायल एक लाइन यहाँ से बोल देंगे तो आपको दिक्कत हो जाएगा
पोस्टमार्टम रिपोर्ट में इट इज वेरी लिमिटेड माय लॉर्ड्स कि उसमें कुछ नहीं कहा गया है माय लॉर्ड्स ने
there is no injury
नो इंजरी नथिंग माय लॉर्ड्स अदरवाइज हम अपने बोल देते हैं हम अपने सबमिट करते हैं if it is a case then only I am arguing
Page 7 लिखा जाए Page 7 of the page तो para 40
केस डायरी मेरे पास नहीं है ना
दो केस का है
मनीषा कुमारी रंडिया देश एज पर विशेष पहचान चिन्ह जन्म रूप बाल तथा आंखों का एज पर इंक्वेस्ट उसके नीचे
आप पोस्टमार्टम रिपोर्ट पहले पढ़िए
हाँ पोस्टमार्टम की रिपोर्ट
पोस्टमार्टम रिपोर्ट तो इंग्लिश में
पोस्टमार्टम रिपोर्ट ये है
इंटरनल
हाँ इंटरनल से ऊपर खाने में पड़ करना इससे ऊपर एज पर इंक्वेस्ट रिपोर्ट लिखा हुआ है यदि कोई चोट जलने का और गर्दन पर बंधन का चिन्ह हो या उसका विस्तृत वर्णन किया ये भी लिखे कि ये चिन्ह मरने के पहले का है या बाद के और उपयोग में किया संभावित संचावरों का उल्लेख इंटरनल लम्स आर enlarged which is forming consistency enlarged weighted around 250 grams both kidneys are enlarged with right kidney such and such left kidney such and such the above noted findings are anti-mortem in nature opinion regarding final cause of death is kept reserved for histopathology report and chemical examination report the IO shall ensure to collect it from the department and give it to FSL Karachi within 5 months 3 months failing in which may lead to destruction of specimen time since death is 6 hours to 24 hours from the date of postmortem a portion of both kidneys a portion of spleen a portion of both lungs has been given to the histopathology examination to the pathology department viscera preserved stomach and its content a loop of small intestine and portion of liver no external injury has been mentioned
no external injury has been mentioned
but
it does not even say that there is no external
if मैं
injury
go and submit मानो if I go मतलब strangulation भी करेंगे तो strangulation में
किसी एक्सटर्नल इंजरी के बारे में मेंशन नहीं
मतलब तब एक मिनट खाली आप एक मिनट खाली कमेंट कर लेना उससे ज़्यादा नहीं बोलेंगे क्योंकि there would be a strangulation मतलब तो हाथ पैर ये होगा there would be a struggle मतलब there would be certain injury मतलब even the part of the strangulation has not been mentioned in the post-mortem report
and why IU and doctor have not been made charge sheeted witness रहते हैं क्या IU and doctor
हाँ ये बोले
यहाँ पे क्यों लिखा हुआ है? It is pertinent to mention here that the IU and the doctor have not been cited as charge-sheeted witness. Yes? What is this? FIR register ही क्यों किए थे? नहीं करना था. You should not have registered the FIR. What kind of investigation and what kind of charge sheet you have filed? Rectify it. They are necessary witness, right? BA number 1673 of 2026. Heard the learned, no. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that the petitioner is the husband and he is in custody since 17/4/2025. He has further submitted that as per the FSC report, no poison etc. was filed in the Vista report. This has been mentioned in the counter affidavit itself. The learned counsel has also submitted that in the post-mortem report, no external injury has been mentioned. However, the post-mortem report is silent with respect to injury. Neither it is mentioned that there is external injury, nor absence of external injury has been mentioned. Nor absence of external injury has been mentioned. It is silent on injury. The post-mortem report is completely silent on injury. The learned counsel submits that the victim died natural death. Counsel for the state has opposed the prayer and has submitted that victim died unnatural death in her matrimonial home within 9 months of marriage. Sorry? And she was only 19 years of age. The learned counsel has further submitted that the victim had died due to strangulation. It is surprising that, as mentioned in the impugned order, the investigating officer and the doctor have not been cited as witness. The learned counsel for the opposite party is unable to explain this fact before this court. After hearing the learned counsel for the parties, the victim having died in a matrimonial home within 9 months of marriage, aged 19 years, this court is not inclined to enlarge the petition only. The learned counsel for the state is directed to communicate this order to the Director of Prosecution and SP of the concerned district, showing the concern of this court as to why the investigating officer and the doctor have not been shown as charge sheet witnesses in the case.
Otherwise, we can come for pre-investigation. Whatever.
Zero. Item 13, DA.18.20.2026.
This FIR registered under section 96 of BNS, but charge has been framed under sections 96 and 64(1) of BNS, along with section 4 of the POCSO Act.
Charge has been framed under section
96 and 64(1) of BNS and section 4 of POCSO Act. This FIR has been registered by the father of the victim, that is
BNS digital.
may I read the FIR?
Please read it.
सो मेरी बेटी कार्मेल मुर्मू के गांव से ही चंदन मांडे द्वारा बाला कुजला का भगा ले जाने के संबंध में निवेदन पूर्वक करना कि न्याय जवाहर मुर्मू 50 अस्थायी निवासियों दिनांक कितना 3/7/25 को योजना हुई चंदन मांडे हमारी बेटी कोमल मुर्मू को उम्र लगभग 16 साल बाला कुजला का अपने पल्सर बाइक शुरू कर बाजार तरफ ले गया। देर शाम तक घर लौटे हम लोगों ने अपना संदेश किया, लेकिन अभी कुछ भी पता नहीं चल पा रहा। उस लड़के का मोबाइल नंबर इतना है जो कॉल लगाने पर सुन को बता रहा है मेरी बेटी इतना हाई स्कूल तीसरी बड़मसिया के बदलाइन में घटना से सभी सवाल घटना कोई ऐसी लड़के के पूर्व में गाँव से दूसरे मुझे जा चुका है अपना।
Earlier also you were doing this. There was earlier case also on this.
ये रेलिगेशन लगाया गया है लेकिन इसमें कोई
आपको तो पता होगा ना आपके ऊपर कोई FIR हुआ था कि नहीं था?
नहीं FIR नहीं हुआ था।
But some allegation is there. Right?
दूसरा था गांव में हुआ था लेकिन वहाँ से समझ गया FIR।
क्या बोला? Yeah, for the informant.
डायरी भी आई।
What do you have to say?
Because out of 6 witnesses, 3 have been examined.
You have been examined.
Yes, but 3 have been examined.
This victim has been also examined.
Next date is on 20th of April.
20th April.
Yes.
Witness produce कर देंगे? बताइए. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the charge sheet has been submitted in the present case under section 96, 64 within bracket 1 of BNS and section 4 of POCSO Act. And the FIR was lodged against the father of the victim alleging that he is minor aged 16 years. The learned counsel submits that the petitioner is in custody since custody बताइए
12/7/2025
12/7/2025 and has been falsely implicated in this case. The learned counsel for the opposite party, the informant, has submitted that out of 6 witnesses 3 witnesses have already been examined, and the next date is on 20/4/2026. Counsel for he has also submitted that there is direct and specific allegation against the petitioner in the FIR, and earlier also the similar kind of act was done by the petitioner. Counsel for the state has submitted that the state would ensure that the remaining witnesses are produced, including on 24/26. इस तारीख को भी आना चाहिए witness. And after hearing the learned counsel for the parties and considering the fact that the petitioner is named in the FIR and there is direct allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that witnesses are promptly produced before the court. Counsel for the state is directed to communicate this order to the SP of the concerned district and also to direct the prosecution to ensure compliance.
Item 14, BA 1845 of 2026.
Statement under section 183 has not been recorded. नहीं है. This is what we have got. ये कॉल पर हुआ उसी से बता रहे हैं आपको. Victim का statement under section 183 has not been recorded. क्या कर रहे हैं आप लोग? What are you doing? Read the FIR, madam. Yes, you argue your case.
The FIR was on 29/9/25 and the custody since 7/10/25. The trial of witness has
Just a moment. FIR on 29/9/25. Custody since
7/10/25.
7/10/25.
And the trial of witness has not been conducted at.
Not yet commenced.
No. And there is no evidence, no CCTV footage. It is only based on mere suspicion. In the time of occurrence, I was on my duty and I submitted my biometric attendance and except to page number 17.
He is a police officer. The petitioner is a police officer.
No, he is a staff of Ramgarh POCSO. And the FIR report delay on 22 days.
Delay of 24 days.
22 days. And the accused is 23 years and the girl is 26 years. Enough minor, mature. And the girl lived.
कोई वीडियो वगैरह कुछ आप रिकवर किए?
कुछ नहीं.
In such cases where you have allegation against the accused that he is using his mobile for video etc. वो तब सीजर भी नहीं करते हैं उनका मोबाइल. You don't consider it necessary to seize his mobile, isn't it? Yes. तो होना तो चाहिए, तो कौन बताएगा किसको? तो आप लोग को FIR रजिस्टर ही नहीं करना चाहिए क्योंकि आप लोग इस लायक नहीं है कि इन्वेस्टिगेशन कर सकें. वीडियो में वायरल कर रहे हैं, एलिगेशन है, उनका मोबाइल तक सीज नहीं करते हैं, तो क्या करिएगा आप? कोई बात नहीं. ट्रायल कमेंट्स नहीं बना अभी तक. For the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that the petitioner is in custody since 7/10/2025 in connection with the FIR lodged on 29/9/2025, and there is delay of 22 days in lodging the alleged FIR. The learned counsel has also submitted that
ये गवाही में भी बोला गया है
Just please hold. जब बेल दे रहे हो तो वकील को चुप हो जाना चाहिए. इतना कोर्ट का रीडिंग आपको अब तक हो जाना चाहिए. The learned counsel for the petitioner has submitted that the trial has not yet commenced and petitioner has been being accused on mere suspicion and he was on duty at his workplace. She has further submitted that the alleged video etc. has not been recovered during investigation. And charge sheet has been submitted. Charge sheet has been submitted. The learned counsel for the state has opposed the prayer for bail. But none of the aforesaid submissions made by the counsel for the petitioner is in dispute. इन्होंने कोई भी बात गलत बोला है. FIR का डेट, कस्टडी का डेट, ट्रायल हैज नॉट कमेंस्ड, सस्पिशन, ड्यूटी, राइट? डिले है. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances, the petitioner is directed to be enlarged on bail. एक चीज और लिखिए. A report has come from the concerned court that the victim was not examined under section 183 BS. The non-examination of victim under the aforesaid section is also unexplained in this case.
Item 15 DA.10.04 of 2026.
Yes, petitioner. Very serious. Workplace में आप workman.
There were a lot of laborers, and in the case diary, I have 41 because charges submitted.
Workplace में ये सब crime नहीं
not knowing. Delay of 2 days also not in देखा. और उन लोग कोई नहीं बोला हम लोग किसी तरह कोई जाएगा. थाना से 500 मीटर दूर है, बगल में ही थाना है. Just for
Not a case for bail at this stage. बिल्कुल भी नहीं. क्या stage है ये बताइए.
स्टेज अभी चार्ज हो गया एविडेंस के लिए. She is not turning up.
She will turn up. आप क्या चिंता करें? लाएंगे ना victim को. ठीक. Heard the learned counsel appearing on behalf of the party. The learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case, and there is delay in filing the FIR of 2 days. Although the police station is just half a kilometer.
800 मीटर कैंपस है उसके बगल में.
800 मीटर.
800 मीटर.
तो 800 मीटर.
800 मीटर.
आधा किलोमीटर से ज़्यादा.
थोड़ा सा.
थोड़ा सा.
वो कैंपस इतना बड़ा है ना, कैंपस से निकल के ही
That's the learned counsel for the state has opposed the prayer and has submitted that there is serious allegation against the petitioner of committing rape by the petitioner who was the contractor, and the offence was alleged to have been committed in the under construction building. At this counsel for the petitioner has submitted that witnesses are not turning up before the court.
She is not charge हो गया.
और कोई witness
नहीं, और कोई नहीं. कोई witness नहीं.
Witnesses are not turning up. Trial has commenced.
अरे चार्ज हो गया. चार्ज फ्रेम हो गया. चार्जशीट नवंबर में ही हो गया था 13 में.
चार्ज फ्रेम हो गया. कहाँ चल रहा है? एसटी नंबर पड़ चुका है आपका.
एसटी नंबर करके देखना होगा. एसटी नंबर दे देंगे क्योंकि बेल उससे पहले का रिजेक्ट हुआ था, उसके बाद एसटी हुआ था. तो ये
Although the trial has commenced. कितना लिख सकते हैं? After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to the SP of the concerned district and also to the director of prosecution. एक लाइन और लिखिएगा. The impugned order reveals that the statement of the victim was recorded under section 183 of BNSS in which she has supported the allegation.
At this stage,
हर चीज at this stage. Working place में is very serious.
वर्किंग प्लेस पे और भी लेबरर्स के तो 3-4 उसके और अलग कॉन्ट्रैक्टर्स भी थे, उन लोग कोई सपोर्ट नहीं है.
ठीक है.
दिस इज अ लंच टाइम, व्हाट आर
Granted at this stage लिखना है.
At this stage.
Item 17 DA.19.04.2026 of 2026.
FIR registered under section 326(2)10. Last evidence case diary was called for 183 statement of the victim has come. There was a love affair between both of us from since 2020 and 2025 case has been lost only on refuse of marriage. It has come in the 180.
The petitioner is already married.
But मतलब in the case
The
diary,
refusal of marriage तो सही है ना?
refusal of marriage.
You can't marry. Can you marry again? As per law.
एक बार 164 देखिए.
आप married हैं कि नहीं है बताइए. Yes or no?
केस डायरी में कहीं नहीं.
केस डायरी में आया
कोई
आपकी वाइफ का
नहीं.
नाम बताएं. दमयंती देवी का क्या नाम?
वो तो
बताएं. आपको बता देते हैं आपकी वाइफ का नाम.
दमयंती तो
ऐसे
आया.
कुछ?
वो तो इसी में लिखा हुआ है यार नहीं.
अच्छा हम ध्यान नहीं दिए. केस डायरी में भी लिखा हुआ है.
But what the allegation of the petitioner is concerned with
Age.
age victim का है 25
And she
petitioner का 30.
she also got pregnant and abortion was done.
Section has not incorporated. In this regard, investigation has not been done. Nowhere it has come that the abortion was time, place, hospital, nothing was in the FIR. Yes, there. 313 has not been incorporated in the FIR. Even my lord charge sheet has submitted only section.
तो आप हैं सिपाही. आप सिपाही होके ये सब काम कैसे करेंगे? चाहिए?
सरकारी नौकरी में इसीलिए शादी करने के लिए वही है ऑन रिफ्यूजल ऑफ मैरिज में FIR. गांव देहात में चलता है सरकारी नौकरी पे है तो
सरकारी नौकरी पे है तो फॉल्स प्रिटेक्स्ट ऑफ मैरिज पे ये सब चलता है.
but on the there was a love affair. It has come in the 183 statement. 2020 से रिलेशन में 2021 से उस समय भी हम मेजर थे, लड़की मेजर थी.
कब से हैं रिलेशनशिप में?
2020 आया है. 2020 से लड़का अजय ब्राउन से बात करते थे. 2021 से वह मेरे साथ
PL number 1926 of 2026. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that the petitioner has been falsely implicated in this case. As per the allegation itself, the victim was in talkative terms and was having relationship with the petitioner since 2020. The allegation is that the petitioner made sexual relationship with the petitioner on the false pretext of marriage. Custody. The petitioner is in custody since 8/11/2025 and was a constable in the excise department of the state of Jharkhand. The learned counsel for the state has opposed the prayer and has submitted that the petitioner was already married. To this, the counsel for the petitioner submits that the victim was throughout major, even in the year 2020. ट्रायल कमेंट्स हुआ?
चार्ज पर है. आज भी डेट है चार्ज पर.
The learned counsel has further submitted that. So far, charge has not been framed. After hearing the learned counsel for the parties, and considering the fact that there is allegation that the petitioner was in relationship with the victim since 2020 and the FIR has been lodged in the year 2025 when the petitioner refused to marry the victim, and considering the fact that investigation is already over, the petitioner is directed to be enlarged on bail with the condition the petitioner and his wife shall not disturb the victim in any manner. एक भी complaint नहीं आना चाहिए.
Item 18 BA 2093 of 2026.
So it's he's the father-in-law. The case under section 82, 238, 3 by 5, 61 by 2, BNS. It's he's in custody since 11/11/2024.
11/11
2020.
2024.
20. Now, the case diary was called for one very important reason. But that where did she die? Whether the well is in the house itself or she went somewhere else and jumped into the well. So that is there in the diary. पूरा अरविंद गिरी का जमीन तथा कुआं
आप बताइए ना कहाँ पर, घर से बाहर है कुआं की?
घर से काफी 50 मीटर ऐसे बता रहे हैं, ऐसे 100 मीटर, जस्ट टू शो कि घर के अंदर में. The second thing which I will not.
Her body was found in the well.
Yes, it was found in the well. There were 2 injuries found. That has also come in the case that although those injuries are such a nature that that is not because of the fact, but because of falling in the well. Anyhow, there are 2 things. One more thing, if your lordship would appreciate it, that before death, Annexure 2 at page 50. This is the dying declaration. Although I do not find it in the case that the police has not taken note of this dying declaration. Wherein she has stated about. Now, the Annexure 3 is her statement just few days before in a different case. Case is like this, brothers. They were in love, but the marriage was not being solemnized. So she filed a case of 376 against her husband and the father-in-law and everybody. That case ended in a compromise, and thereafter she got married. Now, in that case, her statement was recorded in the Annexure 3 at page 16. This statement was recorded on 9/10/2020. And here she says, yeah, I was living very happily. Now,
I have been, although that confession has got no meaning in the eye of law, but that confession, my confession has also been taken by the police. So there was a dispute. The boy, for the last husband, for the last 11 days was not coming to the house. And for that she was, like she felt like that she was neither she's now she's neither with the family, her own family, and neither the husband is with her. And that was one of the cause which pushed her towards committing suicide. That this is the case which overall I have made, and this is the case is there. And he is the father.
पहले आपका submission लिखा था. The learned counsel for the petition submits that he is in custody since 11/11/2025, and the body of the victim was found in the well, which is actually 100 meters away, but it is shown to be just 50 meters away from the matrimonial home. The petitioner is a father-in-law, and he has referred to Annexure 2, which is the dying declaration of the victim. And he submits that though it was not seized by the police, but the petitioner has annexed it along with the bail application. He has further submitted that there was a case under section 376 against the petitioner, which was Sessions Trial number 481 of 2023, which ended in a compromise. Sorry?
Beta.
Against the son of the petitioner, which was Sessions Trial number 481 of 2023, in which there was a compromise, and ultimately the victim turned hostile, and thereafter the marriage was performed, and the victim ultimately was found dead. The learned counsel submits that the petitioner is falsely implicated in this case. The petitioner, the husband of the victim, was not coming home for last 10 days, and due to that reason she died. State. आप कौन है?
I am for the informant.
What do you have to say?
First, the witnesses supported the case. First. Secondly, the sign of the rope was enclosed, which was enclosed and had been found by doctors in the postmortem report also. The confessor statement of the petitioner also, para 70, which he has specifically stated that he has got the victim from the court itself on 9/10, and on 9/11, he has before that night she has tortured all the persons, all the accused persons, including this petitioners also, and they have demanded money also, as well as notice, and thereby they have murdered.
The learned counsel for the informant, while opposing the prayer, has submitted that all the witnesses during investigation have supported the prosecution case. He submits that after the case under section 376 was compromised, the victim was brought to her matrimonial home within 1 month after marriage, and thereafter and immediately before the incident she was tortured. He has also submitted that there is mark of strangulation by rope in the postmortem report.
There is also injury also.
And injury was found
by hardened
blunt substance. आपको क्या बोलना है? The learned, and he has also submitted that there is an allegation of demand of motorcycle and money. The learned counsel for the state has also opposed the prayer and has submitted that the case under 376 was compromised, and ultimately when she was taken to matrimonial home, she was tortured and she was found dead in the well, which is near her matrimony, with injuries. After hearing the learned counsel for the parties and considering the serious nature of allegation involved in this case, including the demand of dowry and torture of the victim, this court is not inclined to enlarge the petition on bail instituted.
Item 19 DA.21.05 of 2026.
Sorry? You want to withdraw? The learned counsel for the petitioner seeks permission to withdraw this application. This application is dismissed as withdrawn. Acquitted. By submitting that the petitioner has been acquitted.
Item 20 DA.21.26 of 2026.
Petitioning custody से आखिर case 24 initially first information
Only 3 witnesses are to be examined. Official लोग बच रहे होंगे बस.
ऑफिशियल लोग इन्होंने हुआ नहीं है
करा देते.
आई इन्फॉर्मेट भी सपोर्ट नहीं की है
करा देते. सारे
69 में चार्ज हुआ है
सारे विटनेसेस का करा देते. करा देंगे ना आप? ये भी तय.
इसी एक पैराग्राफ पढ़ देते हैं.
और 2 ऑफिशियल विटनेस बच रहे हैं. आप एक के बाद एक जो डेट बोलेंगे उस दिन को कराएंगे. आप जो डेट चूज करेंगे. बताइए नेक्स्ट डेट कौन सा? वो आपको नहीं पता होता है. DA number 2126 of 2026. Or the learned counsel is appearing on behalf of the party. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case. And he is in custody since?
Please the showcase. Please the showcase.
30/10/2024. And the trial has not concluded. The learned counsel for the state has opposed the prayer and has submitted that as per the include order dated 30/1/2026, only 3 witnesses are yet to be examined. And 5 witnesses have already been examined. एक चीज और लिखिएगा. The counsel for the petitioner has submitted that the victim has not supported the case. Considering the fact that, and he has also submitted that apparently the official witnesses, amongst the remaining witnesses remaining to be examined, most of them are official witnesses. After hearing the learned counsel for the parties and considering the fact that the trial is in progress and only 3 witnesses are to be examined, this court is not inclined to enlarge the petition on bail. The state is directed to ensure that the remaining witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to the Director of Prosecution and Superintendent of Police of the concerned district to ensure compliance.
अभी थोड़ा सा देख चेक करे तो हुआ क्या कुछ लोग एसआईआर में चले गए. उसमें वो कोड वैकेंट हो गया है. वो दिखा रहा था. तो ये थोड़ा सा
Item 21 DA.21.03 of 2026.
Petitioner was rejected, the bail was rejected earlier? No, not yours. कोई विक्टिम नहीं आया. Heard the learned counsel appearing on behalf of the petitioner. कोई antecedent? कहाँ लिखे?
Para 27. ये petition number 2 का था पहले लेकिन उसमें
आपका petition number 2 का antecedent
था लेकिन एक्विटर हो गया. 2020 का था केस एक पूरा PS 239/2020 लेकिन 13/12/2024 में एक्विटर हो गया.
The learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case, and the petitioners, petition number 1 has no criminal antecedent, and so far as petition number 2 is concerned, he has one antecedent, but he has been acquitted in the present case, in the said case.
During course of death.
Sorry? During Koda PS case number 239 of 2020. Acquittal हो गया इनका इस केस में. Petition number 2 का counter affidavit has been filed during the course of hearing, which is taken on the court. कहाँ है एक्विटल ऑर्डर? एक्विटल ऑर्डर कहाँ है? कब हुआ है?
ये हुआ है 13/12/2024. ऑनलाइन कोशिश की मिला नहीं, लेकिन इंफॉर्मेशन है कि उसमें
The learned counsel for the petitioner has submitted that no victim could be traced. देखिए तो ये विक्टिम का है ना. The learned counsel for the state has opposed the prayer for bail and has submitted that so far as the petitioner is concerned, one name of one victim has been mentioned in the case diary in paragraph number
29.
29. And he submits that the submission of the petitioner that no victim could be traced with respect to the petitioners is not correct. So far as the petition number 1 is concerned, no victim could be pointed out. Correct?
Yes.
After hearing the learned counsel for the parties and considering the fact that one victim could be traced out so far as petition number 2 is concerned, this court is not inclined to enlarge the petition number 2 on bail. So far as petition number 1 is concerned, since no victim could be traced out, he is directed to be enlarged on bail. गलत सबमिशन हमारे पास कभी मत किया करिए, समझे ना? We don't ever do it. पता नहीं था तो डायरी देख के बोलना चाहिए, पता करके बोलना चाहिए, बिना पता किए. हाँ पार्टली अलाउड. पिटिशन नंबर 1 का अलाउड है, पिटिशन नंबर 2 का रिजेक्टेड. एक का इसका कोई फ्यूज का बेल उसमें ऑर्डर है, उसमें लगा रख इसको पहले.
Item 22 GA2182 of 2026.
Case executed in the CCTV immediately the age of the girl is 17 years and 5 months. And there was love affairs. She has given the full account of the entire affair while she was examined under section 160. It is from her statement that there was love affairs between she made several cases with the petitioner and she stayed at Karachi after she was pregnant. Though Dr. Given there is no recent medical help, there is delay in the institution of the but you should consider her age is 17 years and 5 months. And her statement under section 160.
Date of birth is 5/4/2008.
The sucker was found. The sucker was found.
What is the date of offence?
Date of offence 11/8/25.
Date of offence is 11/8/25. 11/8/25 है date of offence.
17 years and 17 years 5 months.
In this case, what question is recording? Because there is a videos viral where
Just a moment. For the learned counsel appearing on behalf of the petitioner, the learned counsel for the petitioner submits that the petitioner is 19 years of age and there was love affair between the parties, and the date of birth of the victim is 5/4/2008, and therefore on the date of offence she was 17 and a half years of age.
पूरा 160 में पूरा FIR में तो
The learned counsel has submitted that. The petitioner is in custody since 13/8/2025. The learned counsel for the state has opposed the prayer and has submitted that petitioner is a victim, and the allegation made in the FIR reflects that the petitioner was taken, the victim was taken away by the petitioner by stating that the brother of the petitioner has met with an accident, and thereafter she was taken to a isolated place and rape was committed upon her. She submits that there is no indication of any love affair between the parties. And the fact remains that the victim is a minor. After hearing the learned counsel for the parties and after considering the allegation made in the FIR and the manner in which just a moment, and the manner in which the offence is alleged to be committed, this court finds no reason to enlarge the petition on bail since stated. It is always like this. क्या stage है बताइए? The counsel for the testimony. The counsel for the petitioner now submits that the charge has already been framed. The trial has already, the charge has already been framed. He submits that the trial may be expedited. How many witnesses are there? The state is वो भी लिख दीजिएगा. The petitioner is also, the victim is also pregnant. Rejection order. The state is directed to ensure that the witnesses are promptly produced before the court. Counsel for the state, as and when they are directed to remain present, as and when the trial commences. The counsel for the state is directed to communicate this order to the director of prosecution and to the SP of the concerned district. You see, in all POCSO cases, under the Act, there is a timeline prescribed, right? तो इसका ध्यान देने का है. POCSO cases में ज़्यादा witness नहीं होते हैं. 4 से 5, 6 witness से ज़्यादा नहीं होते. एक डॉक्टर, एक आईओ, right? एक informant, एक victim. 4 तो ये एकदम fixed है. उसके अलावा कोई एक आध होते हैं. तो इसलिए इतना भी मुश्किल नहीं है उस टाइम फ्रेम को फॉलो करना, प्रोवाइडेड यू टेक स्टेप्स. ठीक है, थोड़ा सा विस्रा में वो एफएसएल रिपोर्ट में जो डिले होता है थोड़ा सा, इसमें तो एफएसएल का कोई इम्पैक्ट नहीं.
हालांकि 17/7 से दैट इज मैटर बट शी इज प्रेग्नेंट, दैट इज मेडिकल रिपोर्ट आल्सो and that is mentioned in the
yes.
So the incident took place in this much.
Item 23 DT.10.04.2026.
Read the FIR. Sorry? Only one witness has been examined. And lastly on 10/7/2005. उसके बाद से क्या कर रहे हैं आप? What are you doing? Yes? But victim has not been examined so far. Independent witness का क्या ही relevance है?
निवेदन है कि मैं सुनिश्चित को आज से लगभग 12 साल पहले अक्षय बोला के साथ हुई थी. अक्षय बोला आज से 8-9 साल पहले काम करने के लिए चेन्नई चले गए थे, जो आज तक घर लौट नहीं आए. बहुत कोशिश करने के बाद भी कोई पता नहीं चला. मैं अपने जीवन को पार्जन के लिए केरल में कोई काम करने लगी. उसी समय हमको सुरेश दैट द पेटिशनर नोट्स से जान पहचान हो गया और राजस्थान का काम मेरे साथ कर रहा था.
Allegation at workplace. Allegation is that at workplace.
With the victim lady lordship.
We will expedite your trial, madam.
On the false pretext of marriage. So, but she has further alleged that Lordship.
She was already married, no?
Married. Her husband went missing, Lordship. Thereafter, she has stated that she was again married to one Suresh Lohra, Lordship, and in a matrimonial house on 28/1/24, this petitioner came and said there is allegation of making the video also by the Lordship, but so far there is no.
Will expedite. How many witnesses are there? There are 7 witnesses, I think. 7. No, 8 witnesses. Will expedite.
Lordship, kindly permit me to place some things, Lordship. Yes. No date and time has been mentioned. Nothing has been stated as to whom the videos have been made by the Lordship. She had again solemnized marriage with one Suresh Lohra.
Just a moment. Date of FIR is?
Date of FIR is Lordship 6/2/24.
6/2/24. She was earlier married with?
She was earlier married. Her husband went missing. She had a love affair with this petitioner. Then again, her marriage was solemnized.
Just a
with
moment.
Suresh Lohra.
Earlier married, then affair with petitioner. It is all these is mentioned in the FIR.
Then again in the bottom of
Affair with the petitioner.
Lordship.
It is mentioned that she has an affair with the petitioner.
पहचान हुई वो राजमिस्त्री का काम मेरे साथ करता था उसने मुझे कहा कि मैं तुम्हारा हूँ तुमसे शादी करूँगा यह करता मेरे साथ मजदूरी का पैसा भी रख लिया था और भाई के साथ शारीरिक संबंध बनाता था उसका फोटो भी खींच लिया और वीडियो बनाकर लोगों को भेज दिया मेरा मजदूरी का पैसा लगभग 1-2 साल का लगभग 1 लाख रुपए में रख लिया वो शादीशुदा था जो हमसे झूठ बोलकर मुझे धोखा देकर मेरा शारीरिक शोषण करता रहा जब मैं वहाँ से अपने घर आ गई तो वह मेरा खींचा हुआ फोटो वायरल कर दिया नो मेंशन एज टू whom the photos have been made viral and when मेरे माता पिता मेरे समाज के समक्ष सगाई अगेन शी वाज मैरिड टू वन सुरेश लोहरा लोहरा के साथ कर दिया जो मेरे जाति के थे दिनांक 28/1/24 को मेरे ससुराल सुरेश सिंह सकिंसो के घर आकर गाली गलौज कर मेरे घर का फोटो खींचकर ले गए और धमकी दिया कि तुम्हारा घर उजाड़ देंगे और जान से मार देंगे नो रिपोर्ट हैज बीन लॉन्च्ड ऑल्दो इट इज alleged that 28 तारीख को थ्रेटिंग दी है but the FIR has been lodged on 6/2/24. There is no medical examination which gets corroboration from the counter affidavit filed by the state, wherein Lordship Para 12, the informant refused for a medical examination. Para 9 of the counter affidavit is also relevant by laws. The independent witnesses have stated that the petitioner, when he refused to marry with the informant, she married one Suresh Lohra, but they were not aware of any abusive.
Yes, madam. What do you have to say?
In paragraph 52 of the case diary, husband of the victim, he has stated that he received one objectionable photo of his wife on his WhatsApp number sent by this petitioner.
So that has been seized?
Mobile of the informant has been seized.
Mobile of the informant has been seized.
It is
Informant is not the husband of the victim.
No.
The mobile has been seized?
But in paragraph 55 there is a screenshot of the photo.
Where is it mentioned in your counter affidavit? Where is it? Is there in your counter affidavit?
No, Lordship, in paragraph 55 of the case diary.
But it is not mentioned in your counter affidavit.
I have not mentioned that about the picture, Lordship.
Show me. That has been seized with a certificate. Where is the certificate? 65B?
No, the certificate is not there.
So उसका क्या relevance?
URL नहीं निकल पाया. That is WhatsApp का URL नहीं निकल पाया.
तो कोई सर्टिफिकेशन नहीं है ना उसका क्या है? उसका क्या रेलेवेंस है?
Although he has stated that the photo had come, but he has
Madam, hold on.
seen petitioner in the village.
He has not
अरे
seen the
बेल देने में इतना देरी क्यों होना चाहिए? रुक जाइए. Stop. Heard the learned counsel's opinion on behalf of the parties. The learned counsel for the petition submits that a report was called for from the concerned court regarding the stage of the trial. She submits that only one witness has been examined way back on 10/7/2025, and thereafter no other witness has been examined, and the sole witness so examined has also turned hostile. The learned counsel further refers to the FIR and has submitted that the victim was already married, and when her husband went missing, she had an affair with the petitioner, but he was found to be married, and ultimately the victim got married to another person. She has further submitted that there is only one date with respect to the allegation that the petitioner had gone to her matrimonial home and has threatened that he would make the video, objectionable video viral. The learned counsel submits that the objectionable video with proper certification is not available in the case diary. And the petitioner is in custody since 35/2024. The learned counsel for the state has opposed the prayer and has submitted that though in paragraph 52 of the case diary some WhatsApp photo has been mentioned, but there is no certification with respect to the same. And the victim had supported the allegation under section 164 CRPC. However, the other arguments based on the FIR as advanced by the learned counsel for the petitioner is not in dispute. FIR में जितना बात बोला है वही बोले ना. She has stated that. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances and the fact that the petitioner is in custody since 30/5/2025, the petitioner is directed to be enlarged on bail. आपको ट्रायल कंक्लूड कराना है आपको कि बेली में रहना है. Counsel for the petitioner has also submitted that the trial itself may be expedited as it may not end up in the conviction of the petitioner. यही ना बोलेंगे आप? तो नहीं कराएं. अच्छा छोड़ दीजिए सब. कोई बात नहीं मत करें. नहीं it's not important. इनको कोई मतलब ही नहीं है विटनेस प्रोड्यूस करने से, तो हम लोग क्या कर सकते हैं? नहीं स्टेट को कोई मतलब. बेल मिला है, शांति से रहिए, आप अपना देखिए आपको जो करना है. हम सोच रहे थे जल्दी खत्म हो जाता, लग नहीं रहा कि आपका कन्विक्शन हो पाएगा. एनीवेज चलिए.
Item 24 DA.10.04.2026 of 2026.
Counsel for the petitioner seeks permission to withdraw this application. This is dismissed as withdrawn.
Pass over case. Item 4 DA.12.08 of 2026.
This is under section 82 of BNS, that is 304B. It is alleged not that due to torture or by the petitioner and his family members, he
died within 4 months.
He committed suicide. As per FIR, he committed suicide. But there are very reasons because she was not happy with her conjugal life.
Died within the law.
Yes, that
carries some presumption.
Presumption is against me. But Lord, it is admitted fact from the FIR also that she committed suicide. It is said that because of torture. Lord, actually the fact is that she was married against her wish to the present petitioner. Therefore, she committed suicide.
PA number 1208 of 2026. The learned counsel for the petitioner submits that the petitioner is the husband, though the victim has died in her matrimonial home within 4 months of marriage, but she had committed suicide.
Yeah, it is
And
there, FIR it is there.
And the reason for death was that she was not agreeable to the marriage.
That is right.
The learned counsel for the state has opposed the prayer and has submitted that there is direct allegation against the petitioner, and there is also an allegation of demand of dowry and assault.
But assault has not been told.
That's after hearing the counsel for the parties, the fact that considering the nature of allegation with regard
Final
to
form has been submitted against
demand of dowry and motorcycle, and the victim died in a matrimonial house within 4 months of marriage, this court is not inclined to enlarge the petition on bail and is rejected.
Item 5 DA.1349 of 2026.
It is seen on 25th of December 2022. The daughter of the informant was missing. Now it was suspected that the daughter must have been enticed away by Bablu Nunmu. Now during investigation, Bablu Nunmu was not on a scent of crime. Now it is the petitioner and the brother-in-law of the victim. They strangulated the victim and thrown her body into a well. This is the prosecution. Now Saeed Ansari, the petitioner, was arrested. Another person was arrested. Now in the case diary, let's say we have confessed that we have strangulated her and thrown the body in a well. So there is a confession, both of them, brother-in-law and me. Now in the post-mortem report, this is surprising, which takes away the case of the prosecution from her that making that confession. Now, if you are going to look at the prosecution, the post-mortem report, the post-mortem report, the cause of death is hard and blunt substance due to the effect of antemortem injury. It is not a case of strangulation. So the post-mortem report. Specific case in the post-mortem report, that antemortem injuries are the cause of death. It is not a case of strangulation.
ऐसा लिखा है क्या नॉट स्ट्रैंगुलेशन या कॉज ऑफ डेथ इज हार्ड एंड
मुझे लिखा है death was done due to effect of antemortem injury as mentioned above. Our injuries are lacerated wound over front neck lacerated, it's not an application. Middle part of absence of trachea with the presence eddies.
सारा गला का ही है कान
गला का lacerated
जो
strangulated
injuries on the neck.
It is
Para 73 of the case diary.
At his confession statement, the body was recovered.
Not only इनके निशानदेही पे ही बॉडी का रिकवरी हुआ है वहाँ से.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case, and as per the FIR, the allegation was against one Bablu, but ultimately the petitioner has been Babu Mohli, and ultimately the petitioner has been made an accused in this case. He has submitted that as per the post-mortem report, the cause of death is shown as lacerated wound near the neck region. And apart from confession statement, there is nothing against the petitioner. The learned counsel for the state has opposed the prayer and has referred to paragraph number
73.
73 of the case diary, that the body of the victim was recovered on the basis of at the instance of the petitioner.
उनके बताए हुए अनुसार 74 में लड़की वन ईंटा पत्थर के साथ बांधा हुआ संग
which was put into the well with bricks. After hearing the counsel for the parties and considering the fact that body was recovered on the basis of confession statement of the petitioner, this court is not inclined to enlarge the petition on bail. Please reject it.
Possible case item 6, DA.10.04.2026.
has granted bail for accident also one co-accused and several other. But there is no criminal antecedent. There is a victim of 7,667.
BA number 1422 of 2026. For the learned counsel appearing on behalf of the petitioner, the learned counsel for the petitioner submits that the petitioner has no criminal antecedent. Victim has. And one victim has come forward to the extent of only rupees 7,667. He submits that under identical circumstances, several co-accused persons from the same FIR have been enlarged on bail. Go detail देंगे. The petitioner is in custody since. आप उनको दे दीजिए ना कॉपी.
एक तो का नहीं आया था, अपलोड नहीं हुआ था, परसों वाला.
ऐसा कौन सा ऑर्डर है जो मेरा अपलोड नहीं हुआ?
कल नहीं हुआ था 1543.
ऐसा नहीं हो सकता है. हम खुद मॉनिटर करते हैं. एवरी केस इज टू बी अपलोडेड.
1543 ऑफ 20.
दिखाइए जरा 1543 कैसे कौन बोल रहे हैं कि अपलोड नहीं हुआ अभी तक?
कल नहीं हुआ.
नहीं रुकिए.
आज अभी नहीं देखे
अभी बता.
एक्चुअली कल था लगा हुआ.
नहीं हमको अपना ऑफिस को भी तो देखना है. बेल ऑर्डर्स का अपलोडिंग एक दिन का भी डिले इज इम्पोर्टेंट. बाकी सब में थोड़ा डिले होता है, विल नॉट से, लेकिन बेल ऑर्डर का अपलोडिंग हमारा एवरी डे टू डे बेसिस पे होता है. आज का ऑर्डर तुरंत नहीं अपलोड हो पाएगा. आज का नहीं हो पाएगा. आज का ऑर्डर मंडे को अपलोड होगा. मतलब आई एम जस्ट मेकिंग इट वेरी क्लियर.
9/4 को किया गया है.
अभी अपलोड नहीं हुआ.
कल
हो गया कल. रोज 7:15 8:30 बजता है हमको यहाँ से जाने में. सारा ऑर्डर निकाल के जाते हैं, बेल ऑर्डर सारा. इसलिए जब ये सुनने में आएगा कि अपलोड नहीं हुआ है तो आपको फिक्स माई ऑफिस. किसका बेल हुआ सब डिटेल दे दीजिए.
3 का दे दिया. एक 1
The learned counsel for the state has opposed the prayer and has submitted that
78 of
and has referred to paragraph 78 of the case diary and submitted that there is one victim.
Dinesh Mehra.
नाम का जरूरत नहीं है, but the amount is 7667. But the fact that similarly situated co-accused have been enlarged on bail is not in dispute. After hearing the learned counsel for the parties and considering the custody of the petitioner since 2012-25 and that similarly situated co-accused persons have been enlarged on bail, the petitioner is directed to be enlarged on bail. ये 2-3 नंबर हैं. एक है BA नंबर 1915 of 26, BA नंबर 1456 of 26 and BA number 1541 of 26. For your information, एक co-accused का reject हुआ.
After yes, that is also that is also.
The learned counsel for the state has submitted that.
With the renew after framing of charge.
The bail application of one of the co-accused, namely Ramzan Ansari, alias Guddu, has been rejected by a coordinate bench of this court in BA number 1290 of 26 dated 10/3/2026.
Review after charge committee.
ये है मेरे पास. कल जो मिला उसका नंबर बताइए. 1543 of 26.
Item 7 DA.10.04.2026.
After framing of charge का reject हुआ है, withdraw करना है.
Counsel for the petitioner seeks permission to withdraw this bail application. Permission is accorded. This bail application is dismissed.
Passover case item 9 DA.1561 of 2026.
Section
7, that is 366 of 96. And 351, that is criminal limitations for this 14 is that.
Married person.
Page 14, married these parts पच्चीस दिन सोमवार को दिनांक 13/5 दिन मंगलवार रात 9:30 बजे से लिखित सोचती उसी वक्त कृष्णा स्वयं के द्वारा दराज हम काटकर फैल दिखाकर जबरन अपने बुजुर्ग वाले में बैठाकर कहा कि चुपचाप रहो हल्ला करने पर हमारे साथ तुम्हारा भाई को भी नाम से मारने इस तरह धमकी देने लगा कहने लगा कि तुमसे शादी कर लो इसलिए लाया हूँ मेरा घर पर रहो। उसकी पत्नी के विरोध करने पर उसके पति जब घर उस वक्त उसके पत्नी से रूम में बाहर से ताला लगा दिया। इस चलते मेरे साथ गलत नहीं कर पाया और गुस्से में कहता तुम्हारा पूरा खाना ऐसी स्थिति में गंभीरता
Where was she recovered from?
She was not recovered. She went to the police station after she went back to her home. The occurrence is of 30. The fire was registered on 20 after 17. And then after she went to the police station for registration of that. Yes, the fact of the case is that this informant wanted to marry with this petition. That is why she came to the house of the petition. And when the wife of the petitioner objected her,
there is no allegation of rape.
No.
क्या बोलना है? उसकी बीवी उसको ताला लगा दी। समझ गए आप कहानी? अटेम्प्ट का भी नहीं है। Custody.
Custody since 1810-2020.
आपकी वाइफ आपकी बेटर बनेगी?
हाँ।
मुश्किल लग रहा है। डेट कस्टडी बताइए। 1810-2020. For the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that there is an allegation that the petitioner had taken away the victim to his house, and when the wife of the petitioner saw her in the house, she locked the victim in the room. He submits that there is no allegation of any sexual assault. The victim is a major lady, aged about 19 years. He submits that the entire incident had happened as the petitioner was alleged to be willing to marry the victim. The petitioner is in custody since 1810. The learned counsel by the state has opposed the prayer and has submitted that there are direct allegations against the petitioner and the victim has supported the allegations. However, the nature and the manner of allegation as narrated by the counsel for the petitioner is not in dispute. Correct? After hearing the learned counsel for the parties and considering the fact that the petitioner is in custody since 1810-25, the petitioner is directed to be indicted.
Item 25, DA.10.04 of 2026.
Oh, this is not maintainable. It has been pointed out by the counsel for the petition, respondent, that the present petition is not maintainable. नहीं है इसमें आप अपना पेश फाइल करें. Counsel for the limitation, I will say when it was filed. The case was filed on 21/2/2026 and has remained pending. भाई आपका डेट दे दिए हैं, अब आप अपना वहाँ पे सेक्शन 14 is always there. बताइए क्या करना है? The counsel for the petitioner does not dispute that the present petition. Sorry?
अपील मॉडिफाई कर देते हैं,
नहीं मॉडिफाई नहीं,
अमेंड कर देते हैं।
नहीं The council आपको इम्प्यून ऑर्डर भी दे देंगे, आपका डेट ऑफ फाइलिंग
उसमें होगा नहीं, लिमिटेशन लगेगा।
नहीं लगेगा भैया, सेक्शन 14 लगता है कि नहीं दुनिया में?
नहीं, इसमें नहीं है एप्लीकेबल।
ओहो,
इस केस में नहीं है एप्लीकेबल।
कैसे नहीं सेक्शन 14 एप्लीकेबल है?
इस केस में मैक्सिमम 90 डेज की अंदर।
अरे भैया सेक्शन 14 किसको बोलते हैं? You are pursuing the case before another forum who does not have the jurisdiction. You have filed a bail application which does not have the, I will not permit this. This is not.
In this criminal case, वही हम बता रहे हैं. Actually, we can see the provision. Appeal has to be filed within 90 days. And in this case, we have already filed an application before this. तो उसको अमेंड करने में क्या दिक्कत है? अमेंड हम कर देते हैं।
नहीं इसमें बहुत ज्यादा दिक्कत।
अमेंड करने में उसको
आपको ये जितना भी इम्प्यून ऑर्डर सब है सब दे देंगे।
तो ठीक है बेटा, अमेंड करने में जो दिक्कत क्या है? अमेंड तो हम कर देते हैं, उसको एक रिक्वेस्ट लिख के
नहीं
अमेंड कर देते हैं। उसका कंटिन्यूअस टाइम बचेगा इसका।
नहीं
इसका टाइम बचेगा।
नहीं मेमो ऑफ अपील दूसरे हिसाब से फाइल होता है।
अरे उसको अमेंड कर देंगे, जो रिक्वायरमेंट होगा।
ये ऐसा है ना, you can't force me to do anything.
I'm not forcing, I'm just requesting, I'm not forcing.
कल परसों भी हम विड्रॉ किया है यहाँ पर, ऐसा नहीं है। डेट ऑफ फाइलिंग
रिक्वेस्ट कर रहे हैं,
कोई रिक्वेस्ट हमको एक्सेप्टेबल नहीं।
बट हम तो फाइल बता रहे हैं कि 90 डेज के आगे नहीं है टू मूव बिफोर द कोर्ट। देयर आर जजमेंट्स की 90 डेज के बाद इसका अपील नहीं ले सकते, बिकॉज़ स्टे शुड बी बार्ड।
ठीक। The learned counsel for the petitioner has submitted that he may be permitted to convert this bail application into appeal. However, this court is not inclined to permit the same. It is sufficient to observe that the case was filed before this court on 21/2/2026 and has remained pending. In view of the admitted fact that
filed within time.
क्या चीज?
That was filed within time because
वो हम टाइम थोड़ी कैलकुलेट करेंगे, हम डेट ऑफ फाइलिंग दे दिए हैं।
हम तो बता रहे हैं कि सबमिशन है कि मेरा ये प्रॉब्लम है कि
जस्ट अ मोमेंट, this petition is not, it is not in dispute that the bail application is otherwise not maintainable, and accordingly this bail application is dismissed as not maintainable. The office is directed to hand over the impugned order to the learned counsel for the petitioner upon replacing it by a photocopy.
Not maintainable in view of the schedule of the
जरूरत आपको मेंटेनेबल है तो बहस करिए, हम सुन लेंगे।
नॉट मेंटेनेबल इन व्यू ऑफ दिस ये लिखा रहने पे
आपको कुछ भी नहीं, आपको आप हमको इस तरह से डिक्टेट नहीं कर
सकते।
अगर आप बोलेंगे
कि ऐसा बात है तो हम बहस ही नहीं करेंगे। अगर
आपको लगता है मिस्टर नीलेश कुमार, माइंड योर लैंग्वेज। कोई यहाँ पर नहीं बोल सकता है कि हम बहस सुनते नहीं। जब ये मेंटेनेबल नहीं है तो हमको ये प्रोविजन ऑफ लॉ लिखने का क्या जरूरत है?
अगर आप बहस कर रहे हैं, अगर आप बोलेंगे कि हम डिक्टेट कर रहे हैं तो हम बहस ही नहीं करेंगे।
आगे से आपका ऑर्डर रिजर्व कर लिया।
Item 26 BS.10.04.2026.
Counter affidavit has been filed during the court proceedings, which is taken on record. Yes.
You start a fire within running page 30.
Yes.
The fire instituted under section 167
काउंटर ये फाइल कर रहे हैं ना,
section 96 and 3/5 of
वो रजिस्टर करने के पहले रजिस्टर बुलाने के बाद का केस
रजिस्टर करने के पहले
जैसे फाइलिंग नंबर मिला लेडीज स्टेट का है और ये जो सर है वो फाइलिंग का रजिस्टर्ड होने के बाद जो मिला है नंबर उसको चेक करेंगे, सेक्शन थोड़ा सा टेक्निकली करेंगे। ठीक,
काउंटर फाइल का रजिस्टर। हाँ बताइए। विक्टिम हैज नॉट बीन रिकवर्ड।
My lord will find in the FIR that it has been alleged that the victim herself left her house on 9/4/2025. On 9/4/2025, she herself left her house. Thereafter, my lord, it has been stated in the FIR that later on, informant suspected this petitioner and one co-accused have taken away the doctor along with. And after 13 days, the instant FIR has been instituted, naming the present petitioner as an accused. When this petitioner came to know that he has been named in this case, then he voluntarily surrendered before the learned court.
Since when are you in custody?
I am in custody since 8/7/2025.
Where is the CD? Case diary? You are in custody since?
8/7/2025. When I have surrendered, then after 1 month and 20 days of my surrender, 1 month and 12 days, my confession was recorded in the police station. After my voluntary surrender, after 1 month and 12 days, therefore my confession was recorded before the police. In the police, my lord, I confessed that my friend has committed murder of the girl and her dead body.
Because she was pregnant.
That all allegations are there in confession, everything is there. I say that my friend has committed murder and her dead body was dropped in the Ganga river. And her sleeper is there.
Where?
Near the bank of the river. Later on, one sleeper has been recovered, and that sleeper has been identified to be the sleeper belong to the victim. Although, my lord, that confession which led to recovery, there is no seizure to the same. The seizure is to the same as not been. And my lord, after 1 month and 12 days of my surrender, and my lord will find that even charge sheet has been submitted.
Yes, I did him.
My lord will find that.
Just a moment. The counsel for the.
Conclusion, whether the petitioner petition is para number 65 of the case diary. Self physical relation of the victim
With the petitioner?
Yes.
Yes.
Para 65, 67.
So investigation तो चल रहा होगा.
नहीं, चार्जशीट जो दिए हैं ना, चार्जशीट दिए हैं, केवल ये दिए हैं.
Investigation is over.
हाँ, चार्जशीट जो दिए हैं सेक्शन 96 में दी, prosecution of minor girl. सेक्शन 96 और 3/5 की, corresponding 366A and 34.
नहीं, पूरक अनुसंधान जारी रखा जाता है.
Against others. कहीं मेरा 90 days हो जाता तो चार्जशीट कर दी.
ऐसा है ना, 90 days में तो इनको investigation complete करके चार्जशीट करना है. But in all cases it is not possible, right? And in further investigation, suppose a body is recovered, तो आपको क्या लगता है कि आपके ऊपर नहीं आएगा वो? आपके ऊपर जहाँ तक चार्जशीट हुआ 90 days का बस उतना ही भर इन्वेस्टिगेशन आएगा. It is not like that, right? Legally it is not like that. You also know, but you think that I may not be knowing.
But my fair conduct, my lord, will kindly be appreciated.
Yes, I am considering your conduct.
I voluntarily surrendered when I came to know that my name is there. On 8/7/25 itself.
Last two is
And I have got no antecedent, my lord.
Antecedent भी होता है ऐसे केस का.
If my lord, there is apprehension that body will be recovered and
No,
I will
not apprehension, not apprehension. The girl got missing and something was found at your confession. Something was found at your confession. This is not in dispute.
There is no seizure list to the same.
उसका सीजर लिस्ट नहीं बनाए हैं.
तो उसके बाद से on the basis of the petitioner confession statement वो सैंडल डिसीज का मिला और उसको आइडेंटिफाई किया गया.
नहीं तो सीजर लिस्ट तो बना होगा ना, कहाँ से मिला?
उसमें तो आया नहीं, पर सीजर लिस्ट तो हुआ होगा, इसमें आया नहीं. और ये
सीजर लिस्ट होगा कौन से पैराग्राफ में?
पैराग्राफ 67 में देखा है.
67 में
68 में देखा जाए 68 में सब कुछ लिखे हैं कि ई साक्ष्य बनाया है लास्ट.
ई साक्ष्य तो बना ही होगा ना.
तो सीजर की तो बनाएंगे.
The learned counsel for the petitioner has submitted that, although it is alleged that on the confession of the petitioner, the footwear of the victim was recovered, but no seizure list. ये है तो स्वतंत्र साक्षी के हस्ताक्षर एवं अंगूठा का निशान लिया गया तथा, but no seizure list has been prepared.
Yes.
Counsel for the state is directed to seek instructions and file a supplementary contract with the witnesses. लेके आइए seizure list. ये साक्ष्य बनाया वो भी लेके आइए. और लेके आइए कि सीजन लिस्ट बनाने का कोई जरूरत नहीं। फाइल कितना टाइम चाहिए आपको?
3 weeks
सीजन लिस्ट बनाइएगा क्या बुक काट के?
बनाएंगे नहीं, वो इंफॉर्मेशन देंगे।
मैं 3 weeks नहीं, इतना टाइम नहीं देंगे आपको।
2 weeks
तो सीजन लिस्ट बनाने का टाइम
1 डेज के बाद जो हमारा
कोई बात
ट्रैक कर लिया
नहीं। जो आप बोले हैं आपका वो सबमिशन को थोड़ा आपका वेरिफिकेशन बहुत जरूरी है। पोस्ट ऑन 20th April
रिकॉर्ड के लिए, इसलिए हम
सीजन लिस्ट अभी लेके आएंगे।
Item 27 DA.2309 of 2026.
Yes, please.
This diary was called for on the last. It's a case of rape, section 64 and 351 clause 3 of BNS.
केस डायरी कहाँ है इसमें? Sorry? Diary है क्या? Diary is not there. Case diary is not there. You have got the case diary?
On that basis only I have filed.
Where is the counter? Diary? काउंटर नहीं, अच्छा काउंटर अभी बाद में लगाया होगा, क्योंकि हम तो घर से लिखते हैं कि काउंटर का जरूरत है, तो इसका मतलब उस समय तक काउंटर नहीं था, अभी ला के लगाए हैं क्या? भाई अपने ऑफिस को बोलिए कि समय पे दिया करें काउंटर, फाइल मेरे पास जाए तो काउंटर के साथ जाना चाहिए।
It's a case, my lord, where the informant has made allegation that 4 months ago she was going to her parental house on the auto of this petitioner, and in course of that traveling, it is said that the auto driver, this petitioner, had taken a photograph of this informant. And further it is said that thereafter both were talking to each other, both are the co-villagers, talking to each other on the mobile phone, and further alleged that the petitioner gave the threatening that she should love with this petitioner, otherwise he will make the photo viral. टेम्पो में जो जा रहे थे फोटो खींच लिए थे, and thereafter it is alleged that he continued talking with her, and 3 months ago, while nobody was in the house, he came and established the physical relationship. As a result of which she became pregnant, and it is said when the matter was came into the notice of her husband, then the husband
and video has been seized.
Nothing.
Video has not been seized. May I draw attention? The FIR has been lodged on 6/12/25. And in that FIR, she has alleged that the occurrence took place about 3 months back. And paragraph 38 of the case diary is the medical report of the victim, in which she is carrying pregnancy of 17 weeks. So it almost corroborates the statement of the victim.
You see, it corroborates the statement of the victim, but the point is that she says that on account of this video which was likely to become viral or which could be viral, everything has happened. Where is the video? She may have an extramarital affair, and when she was caught, she filed that. Where is the video? That the threatening is all entirely on video. You don't see it?
164 statement of the victim has also been recorded.
You see, the point is that 164 is there, she has supported everything, is that?
That video should have been seized. We agree with that notion. Unfortunately, it has not been seized.
In several paragraphs, Your
Any injury, her medical report, any injury, anything. Where is her 164 statement?
It is not with the case diary. They don't send the 164 statement to us. It is being sent to the court.
Paragraph 6, 7 onwards, my lord. Even the father-in-law of the victim has been examined, and what the father-in-law has said कि कई बार इनको ऑटो में बाबर के साथ घूमते देखा गया है, और जब मेरा बेटा सस्पेक्ट किया तो झगड़ा हुआ, तलाक दिया है, और ये उसके बाद ये केस किए हैं, और ये सेवरल पैराग्राफ्स में आया है. She was seen moving around, my lords, with the petitioner in the order. Paragraph 6, 7, 8 onwards. And at this part, it's a case of consenting, and she is a mother of 4 children. Both the parties are married. 2 villagers.
कस्टडी बताइए,
6/12/2025.
स्टेज बताइए,
चार्जशीट सबमिटेड.
Is that correct? That the father-in-law has also said that she was seen.
When the husband of the victim divorced her, he asked what has happened, then he said
That she was having an affair with this person, and thereafter the case was filed.
yes.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner is to custody since 6/12/2025, and as per the allegation, the alleged incident had happened 3 months before the filing of the FIR, and prior to that, the petitioner, who is an auto rickshaw driver, it is alleged that the petitioner had taken a mobile picture of the victim and was in talking terms with the victim, and it is alleged that he threatened the petitioner to establish relationship with her, failing which he would make the photo viral, and thereafter he committed physical relationship with her, and she became pregnant, due to which her husband has given divorce. The learned counsel submits that the alleged photograph has not been seized by the police during investigation, and there is no material to support the allegation regarding the photograph. He submits that in the case diary it has come that the father-in-law of the victim has stated that the victim was found moving with the petitioner time and again, and seeing that her husband gave her divorce, and thereafter the case was filed. The learned counsel submits that there appears to be love affair between the petitioner and the victim, and both are married. The victim also has 4 children. Charge has already been framed.
Charge sheet, only charge sheet.
The charge sheet has already been submitted. The learned counsel for the state has opposed the prayer and has submitted that the victim was found pregnant, and the pregnancy was found to be 17 weeks, which matches with the alleged date of establishment of physical relationship with the petitioner. However, the other submissions made by the counsel for the petitioner are not in dispute. After hearing the learned counsel for the parties and considering the fact that the alleged photograph has not been seized, and also the fact that the victim filed a case after her husband divorced her and she was found moving with the petitioner and also considering the fact that charge sheet has already been submitted, the petitioner and the victim both being married, the petitioner is directed to be enlarged on bail.
Item 28, DA.23.12 of 2026.
I has been lodged for the offense in the section 115 to 126 to 117 to 109, 85, 352, 351, 2 and 34 of the drawing provisions. The corresponding sections are 320.
Yes, टाइप से काम इतना इंजुरीज है
ये मदर इन लॉ है और ये उसका
डिमांड ऑफ डाउरी है, शार्प कटिंग इंजुरीज है,
इसीलिए डायरेक्ट कॉल फॉर हुआ था लॉर्डशिप कि इसमें जो डॉक्टर है जिससे डिमांड ऑफ डाउरी का बात है उसका भी स्टेटमेंट रिकॉर्ड हुआ है तो वो कहीं नहीं बोल रही है, वो साफ स्पष्ट डॉक्टर
मतलब विक्टिम की डॉक्टर
जैसे ये एलिगेशन है कि डिमांड ऑफ डाउरी केवल इन दोनों के बीच में क्लियरिफाई कर चुकी दोनों का मायके और ससुराल एक ही जगह, एक ही गांव में, एक अगल बगल बोल ली और वो
केस डायरी कहाँ है इसका?
कॉल फॉर और नेचर ऑफ इंजरी हैज नॉट बीन उसमें कहीं नहीं आया है कि ग्रेडियंस है कि नेचर ऑफ इंजरी हैज नॉट बीन
शार्प कटिंग
नहीं हार्ड एंड ब्लंट ऑफसेट वही तो सबसे सकता है तलवार से काटने का बात बोलते हैं वो नहीं हार्ड एंड ब्लंट और एक बार
the case diary has been submitted to the court post on Tuesday Wednesday देखेंगे हम ऐसे नहीं देंगे
Item 29, DA.23.2 of 2026.
I'm requesting to take back the case because the petitioner has been granted bail. Nothing more.
How?
The ASJ has granted bail to the petitioner. So we want to withdraw the case.
No, I don't understand. How the case bail has been granted by the learned court?
The offence was under section 103, one of BNS.
The bail application has been rejected, no, by the court.
Yes, Your Lordship, but came to know in senior that the bail recently the ASJ court has granted him bail.
How?
Your Lordship, so we are requesting to withdraw the case.
All your senior. Once a bail is rejected, how fresh application is entertained and granted bail and this is pending before this court?
Acquittal has been
Acquittal.
Yes, Your Lordship.
Counsel for the petitioner seeks permission to withdraw this application. Accordingly, this application is dismissed as withdrawn.
Sorry.
कितना दिन हुआ?
6 months, Your Lordship.
आज का लेसन क्या है? एक्यूटल और बेल में फर्क.
Yes, Your Lordship.
Item 30. 2343, DA.23.43 of 2026.
Yes.
What's the case of committing sexual assault against a minor?
This direct allegation needs to 183 fully supported. What else? Okay.
Charge has been framed on 31/2026. There are 5 witnesses, none of them have been examined to date, and the FIR is at this stage. Mother is informed.
How many witnesses have been examined?
None of them have been examined. Total there are 5 witnesses. Page 17 of it.
तो डायरेक्ट एलिगेशन है, क्या बोलना है आप?
183 statement
183 has not, she has not supported the case.
We doubt it also, let's see. Because in the medical also
Doubt
it has in the medical it has come that there was no recent sexual.
This is direct allegation against her. Or the learned counsel is appearing on behalf of the parties. The learned counsel for the petition submits that the petition has been falsely indicated in this case. And yes, I've seen that. 4 लाइन का देखा है।
मदर इतनी इन्फॉर्मेट ये लोग बोलते हैं कि अपने पिता के साथ गई थी, उसके बाद रात में गायब हुई, कोई उसे ढूंढा नहीं सुबह तक, अचानक से नदी के किनारे वो मिल जाती है। Now she was 18 years. They have tried first. They were going to write 18, and thereafter it has been struck down, and 16 years has been written. The girl, her sister, who was along with the
counsel for the state
victim.
counter file कर दिए। Counsel for the state is directed to file counter affidavit. Office is directed to call for the case diary along with the medical report and the statement of the victim recorded under section 183. Post 127.
Item 31 DA.10.04.2026.
The trial is at back end.
8 witnesses are there, 4 have been examined.
Yes. 4 कब examine हुआ है? Just see 31-10-25.
Yes, also.
उसके बाद ट्रायल आपका खत्म होने पर BA number 2376 of 2026. Heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case and he is in custody since 12/7/2025. The counsel for the state has opposed the prayer and has submitted that as per the improved order dated 31/10/25, 4 out of 8 witnesses were already examined and the victim had supported the prosecution case. She submits that the victim was 16 years of age and there is direct allegation against the petitioner. She has also submitted that a few witnesses must have been examined by now. Few more witnesses. After hearing the learned counsel for the parties and considering the fact that the trial is in progress, even as per order dated 31/10/2025, and there is direct allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court. DNA report हो गया?
Medical report is there.
DNA? FSL? गया था कि नहीं गया?
Police as per the diary is
It was not sent?
not sent.
The counsel for the state is directed to communicate this order to the director of prosecution and also to the SP of the concerned district.
Item 32 DA.10.04.2026.
This case being taken up with the of 2026. I recognize the on that case the diary and medical report.
PA number?
1154.
54. Of?
26.
26. What is the next date?
No next date.
कहाँ से ऑर्डर हुआ? इसको तो चेक करिए। ये नंबर 1154 of 26. Counsel for the petitioner submits that in the case of co-accused, the bail application of the co-accused is BA number 1154 of 2026, in which case diary has already been called for. Medical report, etc., has already been called for. He submits that this case may be tagged with the same. कब
डेट इसमें इलेक्शन डायरी कॉल
कब हुआ था डायरी?
डायरी मोर देन 30 साल।
ये तो आपका डायरी है क्या?
डायरी
इसी का डायरी है ये?
यस।
मेडिकल रिपोर्ट
ये इसी का डायरी है ना? Post this case along with BA number 1154 of 2026 on Monday. Tag कर लेना.
From the daily list, under heading for fresh filing, item 1, ABA 967 of 2026.
The cheat fund matter, madam.
Sorry?
Cheat fund matter, madam.
You file your counter affidavit. Let you file this counter. How much time do you need?
Just 4 weeks. 4 weeks.
4 weeks. और इस बीच इनको कोई अरेस्ट कर लेगा कब? इतना लंबा टाइम किस लिए चाहिए? एंटिसिपेटरी बिल में बहुत लंबा टाइम देने में
Lordship, this is at least कम से कम उसको 10 हफ्ता
ठीक. The learned counsel for the respondent is directed to file a counter affidavit in this case. क्या एलिगेशन है सर आपके पास?
I am one of the director of the cheat fund company. They collected my note. If you are looking to one of the
कहीं ऑर्डर मत टाइप कर दीजिए. बोलिए. I am just trying to find out what is the allegation.
In 165 it has been done.
बहुत दिन बाद पीसी एक्ट का केसेस आया है तो हमको थोड़ा टाइम लगेगा समझने में. What is the recent trend?
The company has collected my note 9 crores 55 lakhs 86,100.
9 lakh
9 crore
हाँ
55 lakh 86,100.
100.
Now they have repaid the amount to the extent of 3 crores 38 lakhs 88,165. The rest of the amount, 6 crores and 6,000 is still to be unpaid. Now I am one of the directors. After that, 3 crores something has been paid. So 420 not to be activated. The part of the amount has been dispersed. Thereafter it is said where
रिफंड करने से 420 नहीं लगता.
part of the refund has been made. Now one of our activities has been granted bail and direction fee in view of the Satendra Antik's case. Because we have participated in the investigation whenever the CBI wanted, we went there and give our statement.
Go and participate. There is no apprehension of arrest. You go and cooperate with them. Why should an anticipatory bail? इसमें तो Satyendra entry you say is applicable.
Yes, yes. So the other co-accused has been concerned. If you not have to do the direction fee for a month. I paid 160. Page 160 is the relevant.
160 है.
160 starts.
Yes, it is there. So there is no apprehension of arrest, no?
No, actually, your lordship may say that in view of the Satyendra Antik's case. Now cognizance has been taken.
Even if cognizance has been taken, if you participate in the
There is no doubt about it.
there is no apprehension of arrest.
No, apprehension तो रह ही जाता है. Apprehension is Your Lordship has mentioned the Satendra Atlas case.
You mentioned that you will cooperate. So there is no apprehension of arrest.
In view of Satendra.
I do not know whatever it is.
वो नहीं this is the lower court.
देखिए अभी बताएंगे क्या है?
If Lordship is Lordship matter can be disposed of because Lordship has rightly observed that there is no apprehension of arrest. They should appear.
Unless such an occasion comes.
They should file a regular bail application. Lordship.
No, you will cooperate. Your Lordship will observe. You will cooperate.
आपको नोटिस हुआ था? Did you appear even once?
ये नहीं once तो appear करता है discipline maintain
No. Did you appear ever once under the notice issued under this in terms of Satyendra until?
Yes, 41 का notice हुआ बाकी
आपका कब कहाँ है? कहाँ लिखे? When you have been cooperating. I'm just asking you. Has any notice been issued to you under section 41A?
That one particular, we know that we have participated in that investigation. There is no failure on our part.
So there is no apprehension.
Your Lordship may observe that in view of Satyendra's case, I have appreciated.
चलेगा? Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner is the director of the chit fund company. One of the directors of the chit fund company, and there is allegation of defalcation. Defalcation?
Not defalcation. Not paying the unpaid amount.
Allegation of not paying the unpaid amount to the investors to the extent of rupees 955.
6 crores 60 lakhs.
नहीं excellent. The 955,86,100. He further submits that out of that, a refund of rupees 3,38,88,165 has already been made. He has submitted that so far as the remaining amount is concerned, the which remains unpaid, उसको पेमेंट करने का मंशा है आप लोग का?
हम लोग कंपनी का कर दिया, हम लोग नौकरी से हटा दिए.
Lordship, may I just make a submission, Lordship? What has happened in this case, Lordship? These companies, Lordship, they had no license from the RBI, nor SEBI, nor the registrar of the companies, Lordship. They created a company, Lordship, then they started the chit fund scheme, Lordship.
Without proper license and
license high news. Thereafter, Lordship, there was a PIL order by this honorable court, Lordship, that led to the investigation by the CBI, Lordship. They collected money from various districts of Jharkhand, Lordship. It was in fact pan-India, Lordship. And so far this particular case is concerned, Lordship, they collected 9 crores. Maybe they have paid 6 crores, Lordship, but still, Lordship, that 3 crores, Lordship, that's ill-gotten money, Lordship. And that is never going to be paid to the investors, Lordship. Investors are very small people, Lordship.
During the course of hearing, he has submitted that now the company has closed. Close हो गया ना company? The learned counsel for the petitioner has submitted that in view of the judgment passed in the case of Satyendra Kumar Antil versus Central Bureau of Investigation and others reported in bracket 2022 bracket 10 SCC 51, and in the case of Siddharth versus State of Uttar Pradesh and another reported in 2021 SCC online SC 615, the privilege of anticipatory bail may be granted to the petitioner. He has also submitted that anticipatory bail has been granted to the co-accused, namely Sujay Das in ABA number 8600 of 2022. The learned counsel for the respondent has submitted that the petitioner was a director of a company who started chit fund business without getting the proper documents from RBI and collected huge amount from common people. And even if part payment has been made, the same will not absolve the petitioner being the director of his liabilities, as the remaining amount, and as there is no likelihood of payment of the remaining amount. However, he submits that the records of the case does not reveal that the petitioner, that any notice to the petitioner was issued in terms of section.
Lordship, this they have made a verbal submission, Lordship, that is not there in the application.
Okay. In the petition, there is no assertion that the petitioner has been served with any notice under section 41 capital A of CRPC. और corresponding क्या है?
35 BNSS.
Corresponding 35 BNSS. And as to whether the petitioner has responded to the same. To this, the counsel for the petitioner submits that, as per his instruction, the petitioner is cooperating, and as and when notice is issued to the petitioner, there is no reason that he will not cooperate with the proceedings. No warrant of arrest has been issued.
No.
He has also cited that till date, no warrant of arrest has been issued against the petitioner. Only summon has been issued. It appears that, अब देखिए मेरा order गलत नहीं होना चाहिए, ठीक है?
Only one submission, Lordship. They have filed charge sheet in this case, Lordship. Therefore, Lordship, now it is for him to go and appear before the trial court, Lordship. Now the trial court has taken coverage as summons have been issued, Lordship. So it's not, we are not going to issue a notice, Lordship, no more, Lordship, because
To this, the learned counsel for the respondent has submitted that once the summons have been issued, there is no question of issuance of any notice under the aforesaid provision of BNSS to the petitioner, asking him to participate in the proceedings.
And the investigation.
Asking him to participate in the investigation, and apparently the charge sheet has already been issued, has already been filed. He submits that only summons have been issued to the petitioner. The petitioner may participate, and there is no apprehension of arrest as on date. ठीक बोल रहे हैं? ये ठीक बोल रहे हैं? Summons issue हुआ है सर आपको? So if you go and I'm just थोड़ा procedure भूल गए हैं, पर दिन हो गया इसलिए समझ. If you go and appear upon summons, will you be taken into custody?
This is what
he will be granted.
He also knows.
Sorry?
Lordship, outside the court, I am submitting, Lordship, he will be granted bail, Lordship. Because, Lordship, once charge sheet has been filed, Lordship, because after charge sheet is filed, our anxiety is only with regard to the investigation, we have filed the charge sheet. Now it is for him to appear in the trial court, participate in the proceeding.
In some cases, my lord, after this Satyendra Antil's case in the High Court was passing in Nevada, in my matter, in Kuti he was taken into custody, even the
upon summons.
Upon summons, then we filed an application here. Then it was looked at that the honorable magistrate said आपको समझ में
Sir,
नहीं
the
आया.
allegations are very serious. हम आपको anticipatory bill नहीं देने को मिलता है. हम सोच रहे हैं कि आपको कैसे protection दें.
आप तो पार्टिसिपेट कर ही नहीं, एक आदमी को उसी ग्राउंड में फेल हो गई. हम बोले कि आपको सत्येंद्र आंटिल्स के केस के ऑब्जर्वेशन में लोअर कोर्ट विल पास एन ऑर्डर.
In view of Satyendra Antil case, the court below will pass order in accordance with that will.
That will on my side.
The counsel for the state respondent has submitted that since the charge sheet has already been submitted, upon appearance of the petitioner, the court it may be left open to the court to pass appropriate order in terms of the judgment passed by the Honorable Supreme Court in the case of Satyendra.
On his surrender.
Upon his surrender. surrender किया भी upon his appearance on summons.
Appearance?
वो petition फाइल करना पड़ेगा इनको surrender कम bail, appearance surrender कम bail फाइल करना। जो technical है वो lordship that I have submitted.
On his surrender come bail application. After hearing the learned counsel for the parties and considering the submissions and the facts as recorded above, this anticipatory bail application is disposed of with an observation that once the petitioner files surrender come bail application, his application will be considered as per law, including the judgment passed by the Honorable Supreme Court in the case of Satyendra Kumar Anton and Siddharth as recorded above. This should be sufficient.
The latest judgment, my lord, which says that after filing of charge sheet, there is no need for arrest.
I will not say anything. I will take 1 or 2 days to settle with it, and then I will take care.
But lady shall do a compilation. The law is settled in Satyendra until April.
Mushir Adam's case also. That once charge sheet submitted, cognizance taken, they never required during the investigation, they never required his appearance. Then we are bound to be.
Bound to be?
Bound to be.
Then it cannot. The accused cannot
7
be
days. Accused cannot put behind bars.
जो judgment देना है हम सब order में लिख देंगे. बाकी I will leave it to the court to pass an order.
They कर देगा. See what your ladyship has mentioned that Satyendra Kumar Anton's case. This is the regular feature.
Item 2.
You have a list of judgments.
I'll give a list of judgments in the proper form.
Yes, this is your case. 1079.
And I am appealing for the
Here, in other cases, they have filed counter. There is a connection to file counter. There is a landholder.
What is the stage of the case?
Stage of the case is an anticipatory bail, though in some of them who are in custody, against them charge sheet has been submitted. So we do not know, so far as we are concerned, against us, whether they are continuing with the investigation or not. That we do
Who
not
are in
know.
a
I am appearing, but I am the special public prosecutor for some matter the next week. So I am appearing in this matter. Lordship direct, lady should file a counter. Generally, we are filing a counter.
You are generally filing a counter.
That is what I said. So there is one supplementary.
Counsel for this respondent is directed to file a counter affidavit in this case. How much time do you need? Post on, we are fixing Thursdays for CBI matters. Only Thursdays. तो कोई एक Thursday बताइए.
30th April.
30th April. नहीं 30th April.
2 weeks हो जाएगा litigation.
30th April थोड़ा सा दिक्कत है क्योंकि पहले से कुछ केसेस रखे हुए हैं. On 7th May.
I'll give that compilation.
Yes, please.
All the judgments.
Item 3, ABA 1213 of 2026.
Under PC Act law. Allegation is that about 298 acres of land has been exonerated in the year 1985 to 2005.
Exonerated means?
From the forest area by tampering the map. Allegation against the petitioner is concerned below. Their ancestors were the purchaser of the said land, and now they are residing over the same. And the petitioners have been implicated in this case. Those allegations have been made against the Amin and the superintendent of Amin who has tempered the map.
Who are you?
I am the purchaser, successor of purchaser.
Is that correct?
My lord, he is one of the beneficiaries of this.
He is not the beneficiary, he is the successor of the beneficiary.
Yes, my lord. And my lord, similarly situated, my lord, that connection to, my lord, they have been granted bail.
Bail or anticipatory?
But only one thing is there, Lord, para 9 is my Lord missing. But it states, petitioners have replied to the notice served under section 41A. Now, Lord, whether there has been sufficient compliance of 41A, Lord, in view of Amandeep Singh Jauhar, Lord, mandated by subsequent circulars in London, Lord. That is not there, Lord, that is not.
We can still grant him anticipation. Anybody has been granted anticipation?
Yes, Annexure 2.
Annexure 2.
Number of persons that I have annexed 2 orders.
Annexure 2 is page number?
Page 45.
Running page 42, it starts from others.
42 and 45. Hundreds of persons have been implicated on the procedure.
Same order करते हैं? Same to same? Just the same facts, identical?
Yes.
They are also the beneficiaries?
Yes.
Case numbers etc. are the same?
Yes.
Annexure 2? सब सही है? Heard the learned counsel reading on behalf of the parties. This is AB number 1213 of 26. The learned counsel for the petitioner submits that the petitioner is apprehending his arrest in connection with vigilance case number 42 of 2010, dated 16/9/2010, for offence registered under section 420, 120B, 434, 409, 467, 468, 469, 471, and 109 of the IPC, and section 13 within bracket 1 within bracket 3 within bracket D and 13 within bracket 2 of the Prevention of Corruption Act, pending in the Court of Learned Judicial Sessions as Roman 2, from Special Judge Vigilance, Hazaribagh. He submits that the case was registered in the year 2010 for the alleged occurrence in the year 1991, and the charge sheet was submitted after a lapse of 19 years on 23/12/2023. It is alleged that the Forest Department submitted village map in which it is not shown, it has not shown any land of village Zorkata. यही है village?
Yes. नहीं, village अंतर है लॉट.
Village?
Large number of roads.
आपका village कौन सा?
हमारा village है वेडमत का.
Spelling?
VED.
आप spelling लिख लीजिए. और village Zorkata, where the petitioner is residing. You are residing? Petitioners. How many petitioners are there?
10 petitioners.
Where have you stated that the property was purchased by your forefathers? This is not. This is inheritance. Inheritance, you have said. Purchase तो नहीं लिखे हैं.
और फादर की प्रॉपर्टी को इनहेरिटेंस कर रहे हैं, परचेज वो जो फॉर फादर हैं उन्हीं के द्वारा सारा किया पुराना ही.
आपका सबमिशन आपका स्टेटमेंट से मैच नहीं कर रहा.
That is come in the Indian order also.
आप खतियानी लोग हैं.
No, but we are purchaser of our ancestors have purchased the state.
कहाँ लिखे हैं? That your ancestors have purchased the state land. If they have purchased the state land, where is the deed?
We are in the position of over the state land. It has come in the Indian order also that we are residing over the state land and cultivating the state, which is page number 50. We also agree, Lord, if the same is the government land, we are ready to leave the state.
You have filed your counter affidavit in this case.
No.
File your counter. आप याद रखिएगा जो हम बोले हैं अभी.
जी.
और आप बोलते you are the purchaser, file your sale deeds. If you say that you are the purchasers, your ancestors are the purchasers of this property, file your sale deed. Registered sale deed. The learned counsel for the petitioner has submitted that the petitioners are the purchasers of the ancestors of the petitioners are the purchasers of the property involved in this case through registered sale deed. But no such statement has been made in the anticipatory bail application, nor any such document has been annexed. Counsel for the petitioner is directed to file a supplementary affidavit with respect to the submissions made in the court. The learned counsel for the state is also directed to file a counter affidavit in this case. Post this case on 7th of May.
Now we are in the position of the defendant and the same fact has been considered in the bail of the
आप पहले जो बोले हैं उसको substantiate करिए फिर देखेंगे क्या करना है. आपका dismiss नहीं किए हैं, आपको time दिए हैं, registered sale deed file करने.
Ownership regarding ownership of the land that may be mentioned. Regarding the position of the land, I will file the document.
आप अपना जो मर्जी हो document. Purchaser बोले हैं तो sale deed लगाइए.
That may be corrected. I have the position.
देखिए सबमिशन में बहुत केयरफुल रहा करिए, हम बहुत सबमिशन पकड़ते हैं. जो बोले हैं वो लिखाए हैं.
I apply for the same note. We have the position holder.
You apply. कितना टाइम चाहिए? बताइए हम आपको टाइम पूरा देंगे.
Within a week.
You do it. I am posting it on 7th.
But according to be corrected to the extent that regarding the ownership, regarding the position.
Possession से क्या मतलब है? You made a submission that your ancestors had purchased the property and you are in possession of the property. That was your submission. I will not permit that. आप अपना करिए. देखिए आप लोग के सबमिशन को हम बहुत ट्रस्ट करते हैं. लेकिन जब मिसमैच हो जाता है ना तो मेरा दिमाग खराब हो जाता है. हमको लगता है कि लोगों को बेवकूफ बनाते हैं.
I file the document regarding the position.
आपको जो मर्जी करिए. I just do not know. I have dictated the order. Whatever you have submitted, I have recorded it. Now you file your supplementary. आप भी काउंटर फाइल करिए. I will not correct it. I have dictated the right order. After the dictation of the order, when I was about to pass an order that you are the owners of the property because your ancestors had purchased the property, गलत हो जाता ना order.
Ancestors were inheriting the land.
क्योंकि आज इतना सारा सप्लीमेंट्री में बेल एप्लीकेशंस था, इसीलिए हम बहुत ज़्यादा ये सब मैटर्स पढ़ नहीं पाए. और आज पहला दिन है, इसीलिए हम सोचे थोड़ा आई विल बी स्लो एंड ट्राई टू फिगर आउट कि व्हाट इज एग्जैक्टली हैपनिंग इन दीस मैटर्स.
Same was.
ये आपका 7 तारीख को रहेगा. आप अपना हम ऑर्डर नहीं
I submit only one thing, so the fact of the matter is that he is in possession of the land, which was what was considered with the honorable coordinate bench.
He made a submission.
Yes.
I have recorded.
Yes.
वो submission में तो कोई doubt नहीं है. He made a submission.
Yes.
चलिए.
Item 4 BA APA 1609 of 2026.
Yes.
Actual background to this case already indicate there are two named appeals. One of them has been granted anticipatory bail by coordinate bench of this one. But the petitioner was a scientist of CSIR Simfer at Dharwad. But there is a system of
Scientist के ऊपर केस.
But in 2015, there was an MOU between the Ministry of Coal and Non-Renewable Energy along with the coal consumers and the coal producers to ensure the quality of the coal. Simfer was appointed as the nodal agency for sampling and checking of the quality. Based upon that, several agreements were entered into by Simfer along with the coal producers and the coal consumers, that is the power producing units. In the guidelines of 2017, the latest one, which is of 2017, prior to that it was 2005, and then prior to that also other guidelines. In research and development projects, out of say 100 rupees, 40 rupees goes for the implementation of the project. 35 rupees goes to the laboratory, and 25 rupees is shared amongst the persons, employees who are involved in implementation of the project. That is called the project fee or the on-rail. Now, this 25 rupees was distributed after a deliberated meeting by two committees, the standing committee and the management committee.
Just a moment. I have to board a flight. So my mind is not in a right state to actually,
And concentration is missing.
concentration is missing.
I can realize.
The second half I'm not holding court. The entire PC Act cases which are listed today will come on next Thursday. And in the meantime, you please voice a finger entry का वो Mrs. Garodia बोले हैं, आप हमको दे देंगे. Or you file your response. You want to file a response. Normally, counter affidavit is called upon.
Normally, but here is a case.
Normally, counter affidavit is called upon.
But here is a case where the co-accused has been granted bail on certain conditions.
We will see that.
So that to that extent we will file our response because whether that fact is matching in this case. Also.
So you file your counter.
I will file my response.
The learned counsel for the state is directed to file a counter affidavit in this case, post on 7th of May.
Great.
थोड़ा एक दिन आप हमको समय दीजिए. एकदम अभी I was not able to focus at all. I was.
With your permission, ma'am.
Yes, please.
There's a matter at item number 27.
You didn't mention it. You have come from outside.
Yeah, my lord.
From where have you come?
11 times, my lord.
11 times you have come.
Yes, ma'am.
For the same case.
Yes, ma'am.
But you never mentioned it.
My lord, I thought that it will be taken
No,
up.
आपको पता होना चाहिए कोड बहुत स्लो चलता है.
नहीं, मतलब 27 नंबर लगा के आ जाएगा. उसको कहीं टॉप ऑफ द लिस्ट लगा दें.
काउंटर आया?
सब हो गया. काउंटर ज्वाइनर सारा हो गया है. और इसमें बेल मिल चुकी है 12 लोगों को accused को.
बेल आपका बेल है क्या?
जी.
रेगुलर बेल? एंटीसिपेटरी बेल.
Yes.
ठीक.
Connected matters.
Connected दो matters हैं. From where do you come?
Chhattisgarh is from Delhi. It is to do with this connected with Chhattisgarh liquor scam.
Can be posted on next Thursday.
Mother, only when requested out of it.
You mentioned it in the morning.
Thursday
को supplementary में डाल दीजिए. Other side कौन है?
But I would be saying about the all anticipatory bail applications, and we get prepared as per the sequence. So, your lordship may take it as per the sequence. 22nd or 22nd serial से इनका 27th है admission matter.
कोई बात नहीं, इससे क्या फर्क पड़ता है? आप दूसरे कोर्ट में जाके मेंशन नहीं करते हैं क्या?
हम तो कह रहे हैं कि एडमिशन में है ही.
कोई बात नहीं, हम सप्लीमेंट्री में लगा देते, टेकअप हो जाएगा, अपना फ्लाइट पकड़ के घर जाएंगे. लिटिगेंट को जहाँ मर्जी हो जाए. Yes.
मतलब one case.
हाँ?
Serial number 43 in DT Cosmic. Lords, I was praying that it should come on Wednesday because I am going out for.
देखिए हम I fixed a date on Thursday और बाकी आपको 6 महीने का बाद भी चाहिए तो हम देख लेंगे.
नहीं हम Wednesday.
नहीं
केवल Monday
नहीं Monday नहीं आएगा. These all PC Act matters will come on Thursday. I fixed a date for that, so it will come on next Thursday. You see what I have decided is, जैसे every day I will, जैसे Monday को you will get 50 cases on the board. वैसे 50 तो हो जाएगा, ऐसा नहीं लगता है कि नहीं होगा, लेकिन अगर मान लीजिए कुछ matters रह जाते हैं, it will be posted in the supplementary list, and then it will continue to be posted in the supplement. जो भी बचेगा वो supplementary list में आएगा. Friday तक आने के बाद Monday को we will put the cap to 50 again. तो पूरा हफ्ता ऐसे ही चलेगा. Remaining cases will be listed on the next day. जैसे मान लीजिए कुछ cases छूट जाते हैं तो Friday को regular bail के, then I will post it on Monday और उसको 50 बनाने के लिए जितना gap होगा, balance 20 बच जाए चाहे 30 बच जाए तो that will be taken. PC map only on Thursday.
one case serial number 14 minor. Similar case number case जाएगा.
हम फ्लाइट नहीं पकड़े, हमको जाना है.
साइबर का मैटर उसमें 30 अप्रैल को रखा गया.
30 अप्रैल को रखा
जी
गया.
हाँ.
वो कौन सा केस है?
सीरियल 14 पर मेरा लगा हुआ है.
बेल मैटर.
जी बेल, रेगुलर बेल.
मतलब सीरियल 14 ऑफ
14 जो है बीए नंबर है,
अच्छा बीए नंबर
2903 जो है,
हाँ
इसमें सिमिलर कोई कुछ का केस डायरी मांगा गया।
अच्छा तो उस दिन रख दें
साथ लेखी का
30 तारीख को इनका कर दीजिए
along with BA number 2754 2026
ठीक है। अच्छा बाकी जो बीए आज के बच्चे हैं ना, आज के बीए बच्चे हैं उसको मंडे को पोस्ट करेंगे और उसको टैप अप करके 50 कर देंगे, ठीक है। और उसके अलावा जो बचेंगे उसको आप दूसरे दिन पोस्ट करेंगे, ट्यूसडे को। PC Act will go only on Thursday, be it regular bail or